Good afternoon and welcome to the Appellate Division First Department's oral argument for today's calendar. I will call out the names of each case on today's calendar and the time allotted. And counsel, please be aware that the time allotted is for you, not for the court. So if my colleagues have additional questions, we will go beyond the time allotted. People versus Raimi Peña. Counsel for appellant, been allotted 3 and 1. Counsel for respondent, 3 minutes. I'm going to give this pronunciation a shot. Shi Shu versus Mataj. Counsel for appellant, 4 and 1. Counsel for respondent, 4 minutes. Deborah K. versus Richard K. and Castle versus Castle are both submitted. Park Armory versus Icon Parking Systems is likewise submitted. Vitucci versus Durst Pyramid et al. Appellant, 5 and 1. Respondent Vitucci, 5. Respondent Fred Geller Electric, 5 and 1. People versus Sean Brown. Both counsel were not present for the pre-call of the calendar. Is appellant's counsel present? Is respondent's counsel present? Hearing none, the case is submitted. De Balcasel versus 1015 Concourse Owners. Appellant, 5 and 1. Respondent, 5. Bryant versus State of New York. Appellant, 6 and 2. Respondent, 6. In Spirit Development versus GMF 157 LP. Appellant, 6 and 1. Respondent, 6. Gould versus OTG Management. Appellant, 3 and 1. Respondent, 3. Platt versus Berkowitz. At the request of appellant, her time has been changed to 3 and 2 instead of the 4 and 1 originally allotted, and respondents continue to have each 3 minutes. People versus Rafael Rosario. Appellant has 6 and 2. Respondent has 6. And Chang versus Phillips Auctioneers. Appellant, 5 and 1. Respondent, 5. Maine versus Cell Source is submitted, and People versus McQueen is submitted. First case on the calendar, People versus Raimi Peña. Counsel, you have 3 minutes.
Good afternoon, Your Honor. Stephen Strother from the Office of the Appellate Defender on behalf of Raimi Peña. Your Honors, this case presents compelling circumstances that warrant an interest of justice grant of a prejudice hearing. The people have not disputed that there was, in fact, a PECA violation here in the sense that the court did not give the warning. Mr. Peña is a 22-year-old with no prior convictions, and his conviction that he pled guilty to is an aggravated felony that ensures that he is permanently barred from ever re-entering the United States. His entire family lives here in this country, and he hasn't lived in the...
Judge Singh, do you dispute that at least Mr. Peña's lawyer was served prior to that time with a notice of immigration consequences?
We don't dispute that his attorney was given a notice of immigration consequences. You can look at our reply brief outlines why we believe the claim is still preserved, but
well, in this assuming preservation, why isn't service on the counsel enough to put your client on notice of the notice?
To put it succinctly, counsel, there's no guarantee that counsel actually gives that document to the client. The whole rationale of PECA, right, is that attorneys don't necessarily do what they're supposed to do, which is why the court steps in. There's no reason to assume that because that counsel actually gives his client a copy of this notice, explains to him what it means, any of that.
Didn't we say in Lopez that service through the attorney is sufficient?
And as I said, Your Honor, you could look. My reply brief contains an argument as to why we believe Lopez was wrongly decided, but I want to focus on the interest of justice claim here because we do think there are many factors there. So I want to mention again that once again, Mr. Pena has these factors. He's first-time defendant, very young. These are factors this court routinely invokes when exercising interest of justice jurisdiction. I also want to make the point that the whole purpose of a prejudice hearing is to flesh out numerous facts that Mr. Pena should be allowed to bring out. We don't know the circumstances of why his family left the Dominican Republic. Maybe they were innocuous. Maybe they were fleeing cartel violence. We don't know how close he was to his family, but we know that he was living with his father at the time of his arrest here. We know that his entire family lived here. This court has said in numerous cases, most recently, People versus.
When you say entire family, are you referring to the nuclear family? Because it would be highly unlikely that he has no family, no cousins, aunts, uncles, which is very not atypical in a Latino family.
Yes, I'm sorry, Your Honor. I do mean nuclear family. I think in my brief I say his nuclear family. And I want to point out that in both Lantigua and Mebween, recent cases from this court has made clear that the prejudice showing in cases like this is not difficult to make. It even says, the chances of success at trial could be slim to none. And even in Mebween, there was the man who this court said could show prejudice was convicted of a misdemeanor by plea when he was facing 14 years and permanent sex offender registration. That's a much more favorable deal than Mr. Pena received. If Mr. Mebween can show prejudice, certainly
although
Mr. Pena
to be fair, your client had 6 prior arrests and 6 open pending cases at the time of this plea. So while he had not had a conviction yet, he certainly wasn't a novice to the system. And in light of those 6 pending cases, this plea was not a bad plea in light of the attack being caught on video.
So I want to make a couple of points on that if I can. The first is that even if he had open cases, this is certainly still his first actual guilty plea, which means that in this record, there's no evidence that he knew he was going to be deported. And like I said, deportation here is for this conviction is a permanent bar to re-entry to the United States. And I understand Your Honor's point about the video, but it is worth making the point that Mr. Pena only pled guilty to attempted robbery. There is no actual proof that he committed an assault in this case. That does matter because if it gets sent back, Mr. Pena just has to show that it would have been rational for him to take a risk at trial. This court has said over and over again that the risk of deportation is so severe, the consequences are so catastrophic for people that they can take that risk even if their chances of winning aren't very good. It is a rational choice.
Is there a video of the attack, client, counselor?
I believe there is a video, although it should be noted. What's that?
Isn't that evidence?
It might have been evidence admitted at trial. It was never actually subject to a suppression hearing.
There was no evidence that he participated in the attack. I thought it was on video.
So the attack is on video. The evidence is not clear that there's any evidence that Mr. Pena actually participated, at least in the record that we have. Mr. Pena identifies himself as present, but he doesn't say, there's nothing in his statement that says, I'm the one doing the attacking. Again, I'm just saying that's what the record shows.
All right, you'll have time on rebuttal. We are way over time, okay?
Of course, thank you.
All right, Mr. Kress, you're up.
Thank you very much, Your Honor. Good afternoon. May it please the court, Stephen Kress on behalf of the people. So I just want to point out, I believe in the felony complaint, it does say that the victim, I believe it says that he referred to the defendants, or I know it's clear from the felony complaint and the VDF that the victim in this case did actually know the defendant and his attackers. So there's no chance of mistaken identity in this case. The defendant was known.
I don't think that was the point. I think the point was, is there evidence and does the complainant anywhere on this record that we have before us specifically say that the defendant was not merely present, but participated in the actual physical assault? I think is what the defendant's argument was.
No, yeah, thank you, Your Honor. And what I was trying to say is that I believe in the felony complaint, it says that the victim informed the swearing officer that the defendant and others attacked him. And then in the VDF, it confirms that there was an identification that was made by the victim that was confirming the defendant's identity, or that he had identified the defendant. And I think looking at those two things together is record evidence that the defendant participated in the attack. Just a couple other points to make. I would actually direct the court to People versus Barry, which is a case we cite in our brief. I think it's on similar factual circumstances, or a similar argument that Justice Singh had made earlier about the defendant's. Well, let me take a step back and say it's actually not clear who exactly was served with the notice of immigration consequences. Could have been the defense lawyer, could have been the defendant himself. But if we assume for the moment it was defense counsel, in Barry, we made the argument that that was good enough to put the defendant on notice, and that under those circumstances where he had received a notice of immigration consequences and actively sought out the plea that he ultimately entered, it would be unlikely he would be able to establish prejudice at a hearing. And I think you have the same circumstances here. And then you add on top of that the strength of the evidence, the favorability of the plea, and defendant's lack of ties to the United States apart from his nuclear family being here. And I think all of that indicates it would be unlikely he would be able to establish prejudice and therefore is not entitled to a hearing.
Thank you.
Unless the court has any other questions, we'd ask that the judgment be affirmed.
Any questions? All right, thank you. Counsel, you have 1 more minute.
Again, the prejudice point here, I think it's just not right. The prejudice, Mr. Pena presents numerous factors that would lead to a grant of prejudice. Again, if a person is their first conviction, they did not know they were going to be deported, their entire nuclear family is here in this country, and the consequence of a plea is that you will be permanently barred from ever returning to the United States, you may take your shot. This court has recognized that in multiple cases, that it would be a rational thing to do. I still have to point out that Mr. Mebouine was held that he could show prejudice when he got a misdemeanor plea on a felony sex offense. If that guy could show prejudice, Mr. Pena certainly can when his family lives here and he'll be permanently barred. I also want to just point out, I don't think that the strength of the people's case is a determinative factor here. Lantigua and Mebouine make it clear that it's not, that even if the strength of the case is strong, prejudice is still a showing that can be made quite easily. But even then, opposing counsel misstates what's in that felony complaint. That felony complaint says that 2 people, not Mr. Pena, demanded money from him, and that a group of people then attacked him. It does not name Mr. Pena as one of the people that did that. That fact is still not present in this record. Now, look, we don't think this is determinative. The purpose of a prejudice hearing is to flesh out these factors that Mr. Pena could present to a court. It would be unjust to have a young first-time offender be permanently separated from his family without a chance to prove to a court that he would have taken the risk to stay here with them. That's the purpose of the prejudice hearing. Thank you.
Thank you so much. All right. Mr. Gumenik? Have I said it correctly? Anshipi Shu? Counsel for Appellate. I can't hear you.
You're muted, sir.
Still muted.
There we go. Your Honors, Robert Gumenik for the appellant.
Great.
In this case, both the plaintiff and the defendant wrote letters where they agreed that there was a settlement. And I want to quote from the March letters. The defendants wrote to the plaintiff saying that the defendants offer a settlement in the amount of $75,000. That was on March 4th. On March 6th, the plaintiff responded, "Please call to advise how it will affect this settlement." So if
Counsel, this is Judge Singh. Are all the material terms agreed to here? Putting aside those issues, wasn't there also a request for a restricted covenant? And wouldn't that be a material term in any kind of settlement, especially of this nature, which is severing a business relationship and what can be done afterwards, competition, et cetera?
Your Honor, yes, there was a request for a restrictive covenant. However, that was dealt with in the earlier correspondence between the parties, where the plaintiff agreed that he would accept the terms set forth in the defendant's letters. So the fact that that was not reflected in the March agreements was, I think, indicative of the fact that they had come to terms on that.
And what were the terms of that, the restricted covenant?
It was no work for 10 years, and no location within 1 mile of the premises. So
I thought it was a 2-year.
was it 2 years? Pardon me.
The 2-year restrictive covenant.
Correct, Your Honor. I misspoke.
Okay.
Thank you.
But in that response, in that November 25th, 2019 response by the defendants to the proposed terms, the defendants stated at the end of their message that the message was for settlement purposes only and is not intended to bind my client absent a fully executed and delivered written stipulation. So how do you get past that language in the series of emails that have gone back and forth?
Well, here's what I would say. I think that the March letters do not condition the settlement on anything other than the payment of $75,000. And that would have been raised in the March agreements if there was some dispute about that. But the defendant's counsel did not raise that in the March letters, and that indicates that the December letters were effective.
Well, wasn't even the March 4th, the March 6th response by plaintiff had a condition to it, right? Which said, my client agrees to accept the $75,000 in one lump sum if paid prior to the court conference with releases and discontinuances. Was that not a condition precedent that was not met?
Yes, Your Honor, I believe that's true. However, I also believe it's true that the parties agree that there was a settlement. And I think the court ought to respect the parties' agreement that there was a settlement.
Okay, all right.
Well,
You'll have
counsel,
time on
obviously one side doesn't think there's a settlement, right? Otherwise, you wouldn't be here right now. You'd be settled, right?
Of course.
And so when you're talking about your response, the plaintiff's response, the plaintiff says, I'm okay with these terms, but not those terms. That's what you said in your response to, here's the defendant's setting out. That's a counteroffer, right? So that, as a matter of law, then there's no agreement. That's withdrawn. You make a counteroffer. So you can't say at that moment that there was an agreement on the other terms. You made a counteroffer. That starts the whole thing all over again.
Your Honor, in my March 6th letter, I said that we said that we would accept this. Your terms are acceptable. Please indicate how we will affect the settlement. There was no reservation of rights, Your Honor.
except with the March 6th email.
When you, right.
2 days later, you then include yet another condition that wasn't met. Either way, well, think about that for your rebuttal time.
Thank you.
All right. Mr. Annenberg?
Good afternoon, Your Honors. May it please the court. My name is Walter Chachi from Delamure and Chachi, and we represent the defendants' respondents.
Well, my apologies for not knowing that you would be arguing. Continue.
It's okay, Judge. Judge Friedman, in denying the plaintiff's attempt to enforce the purported settlement, she basically had 3 cracks at this case to see if there was a settlement. The first one was on October 22nd, 2019, when the parties were in front of Judge Friedman in response to the plaintiff's attempt to have a temporary receiver appointed. On that date, it was stated in open court that the monetary amount of $75,000 was proposed and that there had to be a restrictive covenant. There was no terms set forth as to the restrictive covenant.
Counsel, this is Judge Singh. Was there ever an agreement, as your adversary says, to the restrictive covenant?
Absolutely not. If there was, I'd like to see it. The only mention of the restricted covenant came from my end, where I always proposed 2-year duration and a 1-mile radius. Keep in mind that we're dealing with pizzerias here on the Upper East Side. As a practical matter, I think the judges can see that the money to be paid here is really not the most important thing. The most important thing to us was always the restrictive covenant. This was a case that we were trying to settle for $75,000, and the reason it got to that point was when I told my client that he would spend more than that to defend himself. We needed the restrictive covenant, or there was no deal, and there was never a deal on the restrictive covenant. And to this, the plaintiff himself, in his reply affidavit, when we were fighting about the motion in lower court, he still never agreed to the restrictive covenant. Plaintiff's counsel put forth the stipulation after the 10/22/19 court appearance. All he talked about was the money, never included the restricted covenant. As a matter of fact, we came back to court on November 26th, and we told Judge Freeman, we tried, we can't agree, and the judge referred it to mediation, and the parties consented. So if there was a deal, what was there left to mediate? There was no deal. And then after that, there was correspondence. And we always talked about the money. The amount of the money was never disputed. There was a dispute about when the money was going to be paid, but the restrictive covenant was never agreed to. And the chronology here is, just so you have it in front of you and you can see it in the brief. We have a court appearance on 10/22/19. We have a letter from plaintiff's counsel dated 11/25/19 where he states that nothing can bind this client unless it's in writing signed by everyone. Then in November 26th, we tell the court we can't settle and parties consent to mediation. Then I write a letter on January 17th saying we'll pay the money in one lump sum, but we need the restrictive covenant. Then there's a letter from me again on March 4th saying I'm going to pull my 75 unless we get this done by the 19th, which is when the preliminary conference was supposed to be. And then on March 6th, he writes back talking about the money, but again, doesn't mention the restrictive covenant. And then we have a motion to enforce on April 5. So as Judge Friedman made very clear in her order, and I'm quoting, it is undisputed that no agreement was reached on these terms, referring to the other terms other than the money, and that a written settlement agreement was never executed. Plaintiff's motion will be accordingly be denied. So we know that there was never a written stipulation signed here. Question is, did the correspondence create a binding agreement? Respondents submit the answer is no, because a material term such as a restrictive covenant was never agreed upon. Thank you very much.
Thank you so much. All right, counsel, you have 1 minute.
Your Honors, in the November 25th, 2019 email, This responds to Mr. Chachi's letter setting forth terms that are required. In that email, the plaintiff's counsel says, the points outlined in your letter are acceptable to our client with exception of the payment terms. And the payment terms were later fleshed out in the March correspondence.
So counsel, I guess that's my whole point. That's a counteroffer, right? Start again. That's a counteroffer. And you have to keep going back. So it's not enough to say, I agree to some of it and not all of it. You have to agree to all of it in one place.
Well, I
And
respect.
all the previous stuff goes out.
Well, Your Honor, I'm sorry. That's not how I read it.
Okay.
Okay, thank you so much. All right,
Thank you.
Bertucci versus Durst Pyramid. Appellant's
Good
counsel.
afternoon, Your Honors.
Good afternoon.
May it please the court. Adrian Huron of Cullen and Dykeman for the appellants Durst and Hunter Roberts. There have been a lot of words exchanged in this case, but ultimately it's a fairly simple situation. The sole proximate cause of this plaintiff's accident was his own choice to unnecessarily try to stand on the edge of this bathtub and whack himself in the head.
So is that the theory that we are to evaluate whether it has been established on this record that the plaintiff was the sole proximate cause of this accident? Is that your theory?
Yes, Justice Manzanet, indeed. And in fact, it has been established. It's apparent from the lower court's decision that the lower court simply overlooked the second affidavit of defense witness Robert Bove, where he examined in depth.
This is Judge Singh. Counsel, this is Judge Singh. Dealing with the sole proximate cause issue. Why isn't it sufficient what the plaintiff says here, that he was unable to torque the screw in, sufficient at least on that issue to get it to the jury?
Justice Singh, as I was saying, our expert witness established through the scientific literature, through the specifications of the shower curtain itself, and through surrogate testing that this plaintiff could easly have tightened this screw by standing on the floor. And
I understand that, counsel. Counsel, I read the affidavit, but the plaintiff disputes it. So essentially, what you're asking us to do is to accept the testimony or the opinion testimony of the expert over the plaintiff's position, whose position is that I couldn't torque the screw and I needed to get on the apron of the tub.
Your Honor, two things. First of all, the plaintiff's testimony is purely speculative.
How is it speculative? He's the one who did the work.
Yeah,
on
except on
100
questioning.
shower rods.
Okay, Your Honor, on questioning, the plaintiff admitted he never actually tried to tighten this screw from standing on the floor. He admitted he never actually tried it.
Reach it.
Moreover, this court.
Counsel, please listen to the questions, okay? So he said he couldn't reach it. The defendant's expert completely and totally ignores his testimony. He says he could reach it, but he ignores that the plaintiff says, I tried and I could not secure it tight enough to what I believed was my duty to make sure that I tightened that strong enough so that it would not come down. That was his testimony. You may disagree with it, but that was his testimony. And the expert affidavit does not address that directly.
Your Honor, I disagree. I mean, the testimony, this entire affidavit was for the purpose of addressing this testimony and proving that this plaintiff could have had plenty of torque, 10 times as much torque as he needed to screw this screw in by standing on the floor. And our expert proved that by testing and by the specs and the scientific literature.
So in other words, we're the jury in this case, and we decide that what the plaintiff is saying is wrong, and that the expert is right, that he could stand from the ground and torque the screw in.
Just saying, this court has actually found exactly that in a prior case, Garcia versus MetLife.
Well, but Garcia is different, right? Garcia is a
different.
case where tiling is occurring. I don't know what the plaintiff says as to what he could or couldn't do with respect to the tiling, but in this case, distinguished from Garcia, is the plaintiff's testimony is that he couldn't screw in the set nut without climbing on the rim. Now,
In Garcia, it was grout. He was applying grout, which anyone who's done tiling knows is like applying butter to bread. Okay,
Your Honor,
it doesn't require too much force at all. In fact, you can tile and fix tiling in your bathroom with the use of your finger. So that's a completely different fact pattern. I don't think that case is on all fours at all.
Your Honor, Garcia is also, the plaintiff also testified he had to stand on the tub to do it, and the court disregarded that because it was proven that he didn't. Same thing in Broggie versus Rockefeller. The plaintiff testified he had to stand on his desk.
Judge Scarpullo, what do you say that your expert said about plaintiff's testimony? What did your expert say about plaintiff's testimony that he couldn't do it?
He said that he had 10 times as much torque as he needed from standing on the floor, and he proved it with his step thing. I mean,
so he
if you're
disagreed
saying,
with the testimony, right? So normally,
correct, but he
when we
also
have
proved
two,
it
when we have two
scientifically.
disagreeing on a fact issue like that, it's not an issue of law, it's a fact issue, we send it to the jury, right?
Your Honor, it's not a fact issue in this case because the plaintiff's testimony is speculative. When he was questioned repeatedly, when did he actually try to do this? He finally admitted he never did. He never tried to actually tighten this screw while standing on the floor. So he's just guessing that he couldn't do it. When in fact, our expert proved through testing and through the specs of the device itself that it could be done. Not only that, he had 10
All right,
times
we'll have
as much
time on,
torque
we
that
are
he needed.
over time. And you're repeating yourself. So let's move on to the next counsel. I believe it's Mr. Isaac. You have 5 minutes.
Yes. Good afternoon, Your Honors. Brian Isaac. Judge Maisonette, just for some page references, he said on 519, 520, and 521, and I'm not going to read it because I'm not going to go over my time, that he couldn't reach, and his testimony.
Okay, so Mr. Isaacs, let me stop you there. This is Judge Singh. How
Yeah.
tall is the plaintiff?
5'11".
5'11" to 71 inches?
Correct.
Correct. Okay, the plates that are installed in the wall are at what height?
Depending on
74 inches. 74 inches.
6 feet 6 to 6 feet.
74 inches, counsel. 74 inches. So how many inches did the plaintiff have to reach in order to put the rod in? 3 inches?
Yeah, but Judge.
So, well, hold on, let me finish. So 3 inches. Are you suggesting to me that his arms were shorter than 3 inches?
Absolutely not.
Okay, so he could have, at least if you look at Garcia in the larger sense, he could have reached up there, as the expert testifies, and screwed it in.
Yes.
So my position or my question to you is, again, as with your adversary, why isn't there an issue of fact, not as to sole proximate cause, but as to whether or not this 241 is implicated here because, according to the defendants, the work could have been done from the floor?
Okay, so I do have an answer for you. I'm not sure if you're going to love it, but I have a very
based on the facts, based on his
Understood.
height and the height that he had to work on.
100%. And I'm going to, Judge Singh, if I can, I'm going to give you the page references as well. My adversary is very cleverly altering my claim. I'm not saying that 71 inches can be transmogrified into 74 inches. I'm not saying that a 5'11" guy can't reach up to 8 feet or 8 feet 2 feet. What I'm saying is the plaintiff's testimony was very clear. He said that he was given, this is 280 to 282, he was given his tools, which included a ladder. And he didn't say he couldn't reach. What he said is he didn't have the right leverage. That's the exact word he used. his
Torque.
leverage.
And the response by the expert is that the torque is minimal in
Yes.
this kind of situation because he's putting in a set screw. He's not screwing in the rod into a tile wall, correct?
Correct. But here's the nuance. His practice was not just relating to the Allen screw. That's what I need to try to get across. He had a whole procedure where he stood on the tub because he had a series of things that he did. And let me tell you what they are. And I'm going to give you the page references as well.
Counsel, we're aware of them.
Okay,
I
so
assure you, everyone on this bench has read this record very carefully.
I have no doubt about that. But what he said was that procedure is the one that he employed, Judge Singh, throughout everything, not just in step 5 or step 6, but in the entire step. And remember, this is not just putting grout on a wall. He had to measure the wall. He had to drill into the wall.
Mr. Isaacs, I'm not suggesting that the defendants win here. I'm asking you and I'm probing, is there an issue of fact for the jury to decide whether or not the work could be done safely from the ground? That's it. That's the only issue before us.
And my answer, I'm sorry. My answer is no, because as you know from reading the Price-Borowski case, which also deals with a case I had called Dwyer, in a negligent exercise of discretion, it's not a defense in a labor law claim. Even if a construction worker does something wrong, that's a comparative negligence argument.
I'm not suggesting he did anything wrong. The elephant in the room is whether or not the work can be done safely from the ground. That's it. That in my view is the issue. And that's the problem with the defense argument, and in my view, the problem with your argument too.
And so let me just, I'm running out of time. Judge Manzanek, can I just finish responding to Judge Singh? And then I'll stop. My only point is that if this was something where there was a reason not to do it, somebody said, don't do this. It was something where, as the defendant says, the plaintiff was doing something for his convenience. That's a different story. That's Robinson. That's Montgomery. This is inconvenient. The plaintiff doesn't want to stand on a tub. He's doing it because he has a practice and procedure that's endorsed by his employer, giving him a ladder to do this work. And in fact, he said that he had 6 to 8 other opportunities and he was using the ladder. Nobody told him not to do it. And he couldn't use the ladder in 3 of those because of the garbage that was all over there. That to me is an
sir, just very quickly, how many inches off the ground was this tub apron that he was standing on?
It was, the tub apron is about 5 inches off the ground.
Okay, thank you.
My time's up. I'm not going to go over unless you have any questions for me. I'll stop talking if the panel.
I only have one question. Was the argument as set forth by the defendants in their moving papers that this was anything other than a sole proximate cause case, as opposed to this is not an elevated, an elevation related risk case?
Right. The way
the way it was argued below?
Yes. The way I read their argument below and the way I read their argument on appeal, they're talking about sole proximate cause. That's what they said.
So they didn't cite Garcia, Mr. Isaacs? Garcia was not cited by the defendants? It just, is that right?
Oh, no. I'm saying I'm not saying they didn't cite it. And the truth of the matter is,
what is Garcia? I'm sorry, Mr. Isaacs. What does Garcia stand for?
Garcia stands.
Garcia
stands for the proposition that if you don't have to incur an elevation-related risk in a situation where you're grouting as opposed to drilling, then the court can find as a matter of law that there's
so it's the grouting. The grouting takes it out of the.
Except it's not just grouting, right? There are other cases that talk about that, including window washing and other things, right? Not just grouting. The question is whether or not if you can do the work without creating an elevation related risk, whether the statute applies.
Well, I do just, I'm sorry, Judge Mans, I know I'm going over. Can I just respond to just?
Go right ahead.
Thank you. The Bragi case that is being floated around, you have to read the last sentence of the decision because the defendants don't want you to, but I'm going to ask you to. And I'm quoting, it's not the Court of Appeals, Brian Isaac. Prior to his accident, Plaintiff had cleaned the interior of 8 other windows of exactly the same height as those in room 810, and the record does not show that he needed a ladder or other protective device. If my client suddenly got on the tub after not using the tub to do this in 8 or other occasions, yeah, you have a Bragi situation. But his testimony was this was his procedure. He used it, and he was given an elevation-related device to work with. So I don't think it can be said that it isn't an elevation-related device on this record. Thanks for listening to me.
Thank you. And Bragi he stood on a desk.
He did.
In the office. Right. All right, Mr. Carey, you have 5 minutes.
Good afternoon, Your Honors. This is Brian Carey. I'm an attorney with McElroy, Deutsch, Mulvaney & Carpenter, and I represent respondent appellant Fred Geller Electrical, Inc. Geller was awarded summary judgment on the Labor Law 241 and the Labor Law 200 claims below. We were granted substantially all our relief on the Labor Law 241.6 claim, except for one industrial code that was section 23-1.3, which deals with lighting in a work area. The basis for the claim—
Wasn't that an issue in this case?
Well,
doesn't the plaintiff directly place that as an issue in this case? That his work area was dimly lit?
Yeah, the plaintiff makes that allegation, and as does our co-defendant. And I think that the allegation doesn't hold merit based upon the testimonial evidence. What one of the problems here that Geller was facing—
What evidence in particular? Because I saw nothing that specifically proved that when he was working in that bathroom that power was functional. No one attested to that affirmatively in this record.
We accepted that as true, Judge, in connection with our motion. We were never given the opportunity to investigate this claim because it was never reported to us. Hunter Roberts' testimony was that it reported all incidents of any electrical issue as it occurred to Geller. Geller would look into it and handle it. We know that the plaintiff reported this incident—
Mr. Carey, this is Judge Singh. Whose obligation was it under the subcontract to maintain lighting for the project?
It was Geller's responsibility to install the lighting, temporary—
And to maintain it. So what steps have you shown in the record that you did, that your client did to ensure that in fact lighting was being maintained through the project, including in the area where the accident occurred?
Mr. Wittick was the general foreman on the job for Geller. He testified either as deposition or through his affidavits that the procedure was you install the temporary lighting, then transition that to permanent lighting. That was done in individual apartments. Once it was transitioned to permanent lighting and tested, Geller would move on other apartments, other floors. The record in this case is clear that Geller was far above, on the floors above, by the time this accident occurred. We know that Geller was not anywhere in this particular apartment or even on the 5th floor in the month of January 2016. And this accident happened, I believe, on the 28th of 2016. Mr. Teklis, who was Hunter Roberts' point man, he admitted based upon the photographic evidence that this bathroom had been transitioned to permanent lighting.
But that may be, but the testimony of plaintiff, again, folks, you know, everyone here ignores what the testimony is. Testimony of the plaintiff is that there was no power. So
well, I understand that, Judge, and
doesn't that raise an issue of fact as to whether or not you maintained lighting for the project as a statutory agent?
With respect to maintaining the lighting, the testimony was, and it was unrebutted, that Geller would install the permanent lighting and then move on. It wasn't obligated to come back to do any maintenance unless a problem was reported to it. And that didn't happen here. There was no documentary evidence that anything was reported. Mr. Wittick confirmed that nothing had been reported back to him. And there was no remedial work whatsoever, no documentation whatsoever that any work was done to this apartment after this incident by Geller that would remediate this phenomenon that Mr. Vitucci claimed, that there was no power, that the electric outlets didn't work, and that the switches didn't work. You know, he's testifying that there was a complete failure of power, and nobody supports that position. It was investigated the day of the accident by MedCorp. The individual from MedCorp who examined it does not claim, he submitted an affidavit.
Plaintiff is not credible, and we should accept that. We should accept as a matter of law that there's no credibility with respect to the issue of power.
No, I'm not suggesting that at all, Your Honor. I'm just merely pointing out that Geller was not given the opportunity to do anything, and in fact, it didn't do anything, and yet somehow this lighting, whatever issue that, accepting as true that what plaintiff says happened, nothing was done to remediate the condition, yet it remediated itself. That's all we're suggesting here. And again, we weren't given the opportunity to investigate, so we don't have the records that we'd otherwise like to have had the incident been reported to us, and we sent somebody down, looked at it, we can verify, not verify it. So that's with respect to the plaintiff's claim. And then there was another issue just with respect to a photograph that was taken on the day of the accident by MedCorp as to whether there wasn't a light bulb in the overhead fixture. But there are, according to the pictures, and this is demonstrable evidence, there were two light fixtures in this bathroom, each of which had 3,000 lumens of capacity, which far exceeded the 10 lumens or the 10 candles that were required by.
But if there's no power, how are the lights going to work, counsel? I mean, you don't have to answer that.
No, there's also a service panel in this apartment which nobody verified. Nobody checked to see whether anybody tripped or intentionally shut off a breaker, and the testimony was that was not an uncommon occurrence at this property. Anybody could have done it. It was open. It wasn't locked.
But doesn't that sound like an issue of fact? Isn't that something that you raise before a jury where everyone's pointing fingers at the other person and let the jury make those credibility assessments and determinations? It sort of sounds like to me.
Well, I mean, my hope was that we had established what we could do. We don't have, obviously, the records because nobody told us about this accident. But through the testimony, through the documents that we could get, nobody reported this to us. And it's self-corrected.
Do you wish to address any on your appeal?
Just with respect to one of the things that we had asked for in connection with our motion was that the common law indemnity claims of the cross claims of the co-defendant be dismissed. Judge Getz had found a 240 violation by the defendant, which is negligence. So we felt that should have been dismissed. There was an issue raised in connection with our motion and Durst's motion as well regarding a failure to procure insurance argument against Geller. Geller had procured a $2 million primary and a $9 million umbrella. The trade contract required only $10 million in total insurance. The allegation on the motion was that Geller had only procured $2 million. We had presented through discovery and through the motion certified copies of the policy, so we felt that should have been granted.
All right. You'll have a minute on rebuttal. Okay.
Okay. Thank you.
All right. Mr. Yaron, Miss Yaron, you have a minute.
Very quickly, with respect to plaintiff on page 521 of the record, plaintiff testified he was asked, did you ever try to tighten the rod or lock it into place while standing on the ground? Again, I will ask, did you ever try? Answer, not that I recall. So there's your cite for that. Then I want to turn to Geller's arguments. First of all, labor law 240 is a matter of law, is not negligence. It's statutory liability. It does not preclude indemnity. That's Brown versus 2 Exchange, 76, NY2, D172. As Justice Singh mentioned, Geller and Geller alone had the contractual obligation to maintain OSHA standard lighting throughout this project for the duration of the project.
Counsel, can you address Geller's the contractual argument with respect to the policy? Geller says there's a policy here. Why isn't that sufficient?
Well, I mean, Geller may have had practices and procedures that his people did, but it doesn't obviate their contractual responsibility. Well, the contract speaks for itself.
There's a policy. What's the problem with their policy?
Well, there's policy, whatever they had. The contract speaks for itself, and the contract obligated them to maintain that OSHA standard lighting throughout the duration of the project.
I'm talking about the insurance policy, counsel.
Failure to procure.
The failure to procure insurance. Geller, the last argument raised by Geller that, hey, we have a policy. I know your position, as I understand it, is that the policy is no good. And the question I have for you with respect to that argument Is that something you're raising first time in appeal, or was that issue raised before Supreme Court?
Your Honor, my argument there is just that the Geller has not provided indemnity to us based on its contractual indemnity obligations. And that, I think, is what I'm establishing here, that the lack of lighting does trigger its contractual obligations to indemnify Durst and Hunter Roberts.
All right. Mr. Carey, you have 1 minute.
Sure, just briefly, Your Honor, thank you. With respect to the Labor Law 240 in indemnity or negligence claim, Rizzuto versus L.A. Wagner Contracting Company, which we cited in our brief, stands for the proposition that a violation of Labor Law 240.1 establishes conclusive negligence. So other than that, I don't have anything further to add.
Thank you so much. Thank you all.
That's it.
All
Thank you.
right. Vanessa Caso de Balcacel versus 1015 Concourse Owners Corp. Mr. Schneider, you have 5 minutes.
Yeah, sure. Thank you, Your Honor. Thank you. I guess I'll just cut right to, I think, probably what is the elephant in the room. Is this just a question of fact where we've got differing testimony, meaning an affidavit from the plaintiff's husband that apparently contradicts the notion that there was no notice of these leaks? The testimony of the plaintiff at her own deposition was that there had never been another leak other than a month and a half in this kitchen, and that leak was because of a washing machine on the 6th floor. Entirely different.
Was there evidence that the washing machine was removed?
Yeah, so the defendants were the ones that told her about the washing machine issue, and her own testimony was that there was never another problem for a month and a half until this one, when
that doesn't answer my question, counsel. As I understand the record, it was a violation to have a washing machine in this building, correct?
I don't know if that was what the record established, that there was a violation.
I thought that Mr. Peralta's either affidavit or testimony said so, and I believe Mr. Lavoti, if I am pronouncing his name properly, also said so. That no one was supposed to have a washing machine that had not been, certainly not installed by the building.
Your Honor, you may be correct on that, and I wasn't focused on that for purposes of today. I can certainly search the record to see if it was removed or not. The argument that we're making is that that was a totally separate situation, whether it had been removed or not. The situation that occurred on the day of the incident was totally different. It had to do with a sink that had been left on in the kitchen 2 levels above.
So, counsel, this is Judge Scarpullo. My question to you is, does everyone agree that the cause of the leak, does the plaintiff agree that the cause of the leak was the pinprick in the pipe and not the washing machine that you didn't take care of 2 months prior to that? Is there no fact issue as to that?
My response, Your Honor, to that would be that the reason why we believe there's no fact issue is certainly no one has come in to dispute that. I understand the point, though, that the plaintiff is obviously 2 levels below and wouldn't be able to go to the 6th floor to say one way or another.
And isn't that plaintiff's whole point, that I think that the leak occurred because of the washing machine 2 months ago and not this pipe? And isn't that a fact issue?
To just add to Justice Scarpullo, the tenants on the 5th floor were not there. They were in Puerto Rico.
The tenants on the 5th floor? You mean the tenants on the, is that what you said,
Your Honor? Above the subject apartment and below the washing machines. They were not present at the time of the leak.
On the day of the accident?
Right.
Right. Yeah, so, I mean, the argument that we're making is that there was a month and a half. This was not a recurring condition, which is, I think, the argument being made by the plaintiff, that there was a recurring condition that was occurring within this kitchen that wasn't taken care of by the people.
Well, let me ask you, how often does it have to leak to consider it recurring? It has to happen every day or every other day for it to be recurring? Or can a recurring condition happen when certain conditions in the offending apartment exist, which may not happen every day? But if water continues to come down through the same spot in my ceiling, regardless of what it is, right? Is that not an issue for us to consider? Is that not an
I would
issue?
agree. I would agree, Your Honor, that if that were the testimony, then that would be a question of fact. But the plaintiff's own testimony was that there was one time a month and a half prior. This wasn't something that, as Your Honor had just mentioned, something that was continually happening. This was
But this
a
is what
one-time
I'm
event.
saying. If it happened in February and now happens again in the end of March, I don't know that I wouldn't consider that a recurring condition. The fact that it's only happened twice, I'd be concerned it's going to happen a third and a fourth time. Do I have to wait for that third and the fourth time in order for my landlord to address the issue or at least investigate it?
And I think that's where the issue then comes back into the sworn testimony was that it was a washing machine issue a month and a half before, and the testimony of the man who fixed it was that it was an issue with a hole in the pipe on the day of the incident.
But I mean, counsel, counsel, this is Judge Scarpula. That's your witness's testimony. Isn't the plaintiff's testimony that it wasn't fixed? And I think it was. Number one, the reason why it's important that you knew a month prior to that is for notice, right? It was never really fixed. And I think that was the first question Judge Manzanet asked you was, is there a record showing that it was actually fixed? And you said, I don't know. So if you can't point us to it, then we don't know. And why couldn't it be a month and a half later? You've got notice that this washing machine is creating a leak, and a month and a half later, it creates another leak. It doesn't have to be a recurring issue. It's an issue of whether you have a notice that there is a problem. It doesn't have to be like the grocery store with the spraying the fruit. It has to do with whether or not you have notice.
My response, Your Honor, would be, so if the idea is that there was a problem with the washing machine on the 6th floor a month and a half earlier, and that washing machine was causing an issue where it was leaking when it was being used, the notion that the washing machine wasn't used for a month and a half before this incident, and the next time it was used was a month and a half later, I think that strains a little bit of credulity, but I understand the point.
Except, counsel, that on this record, the reason that there was a leak from the washing machine, as per the superintendent who checked the unit, he said that the reason it leaked was because the tenant in that apartment had the hose suspended into the sink instead of the way it should be attached. So perhaps the tenant in that apartment was more careful for a period of 6 weeks until this second leak. We don't know.
We also don't know how often they wash their clothes. Maybe they just washed a lot of clothes that day.
That's a problem. The problem is it's hard not to see an issue of fact here.
All right, you'll have time on rebuttal.
I understand the point.
Okay. Mr. Isaac, you have 5 minutes.
Yes. Your Honors, I think you've kind of hit my points. I did want to just point out legally that I believe the rule is, believe it or not, based on an old case decided by your court, Rulon against Wilson, 29 AD 307, First Department 1898, but still good law. Knowledge
washing machines, though, Mr. Isaac.
Yeah, no, I know. It says, but this has been followed recently in Rodriguez and Spaeth. Knowledge of a dangerous condition in one portion of the structure may have imposed upon the owners an obligation to examine other portions of the structure for defects arising from the same cause and to ascertain what was ascertainable in the exercise of reasonable care. Justice Manzanet, you asked whether or not there was testimony that the washing machine wasn't supposed to be there and wasn't supposed to be routed to the sink. There is. It's 364 to 371. And I would only point out, because I don't need to speak if you have my points, that on page 588, even though it's in conflict a little bit with what the plaintiff said, the plaintiff's husband said there were 4 or 5 leaks, and one of them occurred in March where the plaintiff actually slipped. And these leaks weren't occurring in different areas. They were in the exact same spot where the original one came in. So if nobody repaired it, we don't know. And at trial, I certainly have to prove my case by preponderance of the evidence. But in a summary judgment motion, it's the defendant who becomes the plaintiff and has to disprove my allegations as a matter of law, which wasn't done here. There's nothing else. I'm happy to rest on my brief.
Mr. Isaac, is there any dispute as to what caused the water to migrate into the apartment on the day of her accident, the plaintiff's accident?
Well, according to the superintendent on the day of the accident, he said that he went up to the apartment and he saw frozen meat that was, I guess, submerged in H2O. But we have absolutely no proof, Judge Higgett, whatsoever as to how that water would migrate, not one floor, but two floors, and how there'd be a stain in the exact same spot where the February incident occurred. There's just nothing there because they didn't inspect it. And as a defendant, that may work a trial, but in a summary judgment motion, it's lethal. And I would point out, as you know from reading the briefs, obviously, there's nothing here about when the area was last inspected. In fact, the evidence shows that it was never inspected until plaintiff was injured. So you don't get summary judgment on that factual record. Thanks for listening to me.
Thank you. All right. Mr. Yaron, you have, no. Mr. Schnitt, you have 1 more minute.
I think that, did you mean me, Mr. Schneider?
Schneider, I'm sorry.
That's okay.
I have
okay.
it written wrong in my my notes. Forgive me.
No problem at all. So just on the very last point, and I certainly won't belabor any of this any longer, but on the very last point that was made by counsel, he was when he was referring to a spot in the exact same location, that was from an affidavit that was put in opposition to the summary judgment motion by the plaintiff's husband that totally contradicted the plaintiff's own testimony.
But so what? Are you suggesting that husbands and wives agree on everything?
Well, no, Your Honor. What I'm
Touché.
The only thing I'm suggesting. The only thing I'm suggesting is that there is case law on what a feigned affidavit.
No. I'm sorry, counsel. What was it? Was the husband deposed here?
So the husband was not deposed.
So I don't think the case law applies the way you're suggesting it applies. I agree it might be an issue of credibility for trial for the jury to consider, absolutely, but not now.
Understood, Your Honor.
Okay.
I'll leave it at that. Thank you.
All right, Mr. Schneider, I am going to tell you why I thought your name was Mr. Schneidet. On your Zoom identification, your name is spelled incorrectly and it has a T instead of an R. So my apologies, but you may want to fix that. Okay?
Thank you, Your Honor.
All right, you have a good afternoon. Bryant versus State of New York. Mr. Emery, you have 6 minutes.
Thank you, Your Honor. It's Richard Emery for claimant David Bryant. I want to be clear at the outset that all we're talking about in this entire argument is the gatekeeping function of 8B3. Mr. Bryant will have to prove, if we get a remand, that he, by clear and convincing evidence, he was innocent of this horrible rape and murder of an 8-year-old girl for which he was falsely convicted and spent 43 years in prison from the time he was 17 until the time he was 60 years old. To this point, the vacating court, Judge Sweet, said the following. Here, the serological evidence in combination with the other presented evidence, and that's key, the Tyler and Cassine affidavits, establishes a credible and compelling claim of actual innocence. And faced with such, it is more likely than not that a reasonable juror would have a reasonable doubt about petitioner's guilt. Critically, that's the touchstone of 8B3. The touchstone is innocence. And the statute and the legislative purpose make it clear that if there's a reasonable showing of innocence, a claimant should be entitled to go forward to make the case before the same judge, Judge Size, below in the Court of Claims, that by clear and compelling evidence, he is innocent and worthy of compensation for the 43 years he falsely was convicted and spent in prison.
Counsel, yes. This is Judge Singh. Was the evidence, the blood testing, was that newly discovered evidence that was not previously discoverable?
Well,
Couldn't that have been done back at trial with respect to the testing?
Parts of it were and parts of it weren't. The Cassine affidavit, the Shaler affidavit in the record, the Shaler expert affidavit makes it pretty clear that the secretor status and some of the refinements, which were probably not available in 1975, but the basic proposition, which was the basis for Judge Sweet's finding that there was ineffective assistance of counsel, was that he could have determined that David Bryant was B, and that the donor of the actual killer was O. And that was the basis of Judge Sweet finding that there was ineffective assistance of counsel. But in so doing, as a prerequisite to that finding, and as a necessary finding in order to reach the ineffective assistance of counsel aspect, Judge Sweet had to determine that there was credible and compelling claim of actual innocence. And that is the touchstone of this statute. That is what opens the gate to allow us in the door.
But sir, I'm sorry, aren't under Court of Claims Act 8-B3,
yes,
the legislature has specified, among other things, that there has to be the vacatur of the underlying judgment of conviction has to be one of enumerated predicates. And I think we all can agree on that. That's pretty clear. That's what the statute says. Then there is case law in the wake of the Court of Appeals case Baba Ali from this court that suggests that we can only look at the actual basis that was employed by the court that vacated the judgment of conviction. And so if I'm accurate in that assessment of where the law stands, how can you succeed even at this early juncture? How can your case proceed given that Judge Sweet granted habeas on the basis of ineffective assistance of counsel?
Ineffective assistance of counsel repeatedly has been found by the Second Department, by the Court of Appeals, and in Coakley by this court, which Justice Mazzarelli sat on Coakley, affirming a long Weisberg decision, which was a full and thorough analysis, as not a bar to going into 8B3, going from 8B3 to 8B4 to prove compelling evidence of innocence. The fact of the matter is any necessary prerequisite finding to the ultimate finding of ineffective assistance of counsel is fair game under 8B3. Multiple courts have said that. And the fact that the statute says the grounds for vacator is certainly the case, but it is, in fact, as a necessary prerequisite, grounds for vacator. And the courts have a great deal of slippage in what, and actually disagreement. The Fourth Department is just wrong on these issues, and there are cases on point with our case that are just wrong, and we contest them. But there is a dispute between the Second Department, this court, and the Court of Appeals.
Mr. Emery, this is Judge Singh again. And going back to the SDNY finding, was that a finding of actual innocence? Wouldn't it be more fair to characterize it rather that it was the basis or predicate for the equitable tolling?
That's absolutely correct. It was a finding based on the facts that it is likely by that is compelling.
So it's your position it was a full finding of actual innocence. I'm suggesting it may not be because it was just sufficient to toll the statute of limitations. No,
I do not say it's a full finding of actual innocence. I say it is by preponderance of the evidence highly likely that there will be a finding of innocence, and that tolls the statute of limitations. That finding was necessary for Judge Sweet to go forward with the ultimate grant of the writ on ineffective assistance of counsel, and therefore completely fair game for this court and the court below, and fulfilling the intent of the legislature as a gatekeeper. The 44010 criteria are for vacating a conviction. They are referred to at 8B3 for purposes of gatekeeping for determinations of likely innocence that then allows you to go forward and prove by clear and convincing evidence that you are innocent. It's just a gatekeeping function, as was the Judge Sweet finding, a gatekeeping function. And there are extremely similar activities by each judge, by this court, by Judge Size below. It should have been found that it was there was new evidence. By the way, the Tyler and Cassine affidavits were by themselves absolutely clearly new evidence. The Tyler affidavit at Rule 68 shows how the police manipulated the evidence, manufactured the evidence in this case, took a 9-year-old boy, made him into the main witness in this case by distorting his testimony. Mr. Tyler came forward on his own when he read newspaper articles about.
So you're suggesting prosecutorial misconduct?
No, it's not prosecutorial misconduct. It's police misconduct. There was very serious and they beat a confession out of my mentally challenged client, David Bryant. He was held all day and he was beaten and he ultimately confessed and then never confessed again. Of course, if he'd confessed again, the parole board would have let him out long more than 43 years later, but he would never make that same mistake twice. He felt so terrible about having been coerced to confess that he stayed in jail probably an extra 20 years because he would not tell the parole board what they wanted to hear. This is one of the most egregious violations by the police that you can imagine. There's nothing worse than taking a young, mentally challenged boy, putting him in prison for 43 years, from 17 until 60, and then denying him compensation when it's clear that he was innocent. Now, I say it's clear, we get to prove that. Yes.
Was there anything that would have prevented the district court judge in the writ from basing the decision on those two affidavits that you just mentioned as newly discovered evidence, understanding that that would be the only way under the statute that he would be able to recover? And what are we to draw from the fact that, notwithstanding his findings, and we have to presume that the judge understood this, what are we to do with that the judge chose to base its decision on ineffective assistance of counsel instead of the newly discovered evidence?
The $64 question, Justice Manzanet, and I'm so glad you asked, because it's fascinating. There is no ground under ADEPA, under the habeas statute, for newly discovered evidence. The only way Judge Sweet could vacate this conviction, which is what he does, is on ineffective assistance of counsel. And that's why he had to say it wasn't newly discovered evidence, because if he said it was newly discovered, then counsel at the time of the trial wouldn't have been ineffective. So the practicalities are that he clearly knew that David Bryant was innocent, and he had to thread the needle through the ADEPA problems by finding that, yes, there was newly discovered evidence in Shaler and Cassine, but the serological evidence, which was the evidence that should have been presented at trial, could have at least in part been presented at trial, and therefore gave rise to a likely innocence finding, which in turn waived the statute of limitations, as Justice Singh has pointed out, and allowed the vacation on the basis of ineffective assistance of counsel. There are a number of other cases where ineffective assistance of counsel has been the ultimate ground, but courts, Turner in particular, in the Second Department, Harris, Coakley in this department, very important case, Coakley.
But counsel, going back to Turner, wasn't Turner based on what the prosecutor did?
Right. Yes, but the ultimate decision was ineffective assistance of counsel. They went back and looked behind the ineffective assistance of counsel in Turner and said they didn't turn over the right records, and the prosecutor withheld them, and that's prosecutorial misconduct, which gave rise to the 8B3 gatekeeping lift. They lifted the gate.
Mr. Emery, aren't we compelled, though, to follow our own decisions in Rosario and Green?
No, sorry.
Oh, no, go ahead.
No, because Rosario and Green had no underlying necessary finding which qualified for 8B3, as exists in this case. Rosario and Green were simply ultimate decisions that there was no finding in the vacating court. Here, there is a finding in the vacating court. I read it to you. I read it to you at the outset of this. And you have every basis to go back under the record, under Turner and under Coakley itself, and under Baba Ali, which is a very important case in the Court of Appeals, that allows you to go underneath the ultimate finding to look at the record of actual necessary findings. You can't look at alternative findings, but you have to look at necessary findings. And here, in the ADEPA context, Judge Sweet made it a necessary finding that what I read to you was the case. Therefore, the 8B3 the gate should be lifted, and he should be entitled to get recompense for the horrible false conviction that he suffered for 43 years.
Thank you so much.
Can I just say one more thing before we?
Can we do that on rebuttal, counsel? We've gone on for almost 15 minutes.
Oh, I'm sorry.
Yeah, it's all right, Mr. Group. And I believe, yes, worry not, you will be given sufficient time to make your arguments as well. You may proceed.
May it please the court, Mark Root for the state of New York. I'll try to cut to the chase to make things clear. The principal point of disagreement between the parties is whether the federal court's finding that Bryan satisfied the requirements for equitable tolling is equivalent to a vacatur under 4410(1)G. It is not. CPL 4410(1)G contains a requirement that newly proffered evidence must have been unavailable at the time of trial, notwithstanding
So Mr. Emery suggests that at least in part, that's correct. Presumably there have been a lot of advances in technology and the testing has changed. So why isn't that a good argument?
Well, for a couple reasons. First of all, it has to be based on the district court's findings. There's nothing in the district court's findings that this could have been produced in 1975. To the contrary, the district court's expressed findings, and I'll just read the language, was that Bryant was, quote, aware that serological evidence existed and was relevant to his conviction, unquote, but did not pursue that evidence until 2005. The court concluded that fact pattern demonstrated, quote, the opposite of establishing due diligence. That's 181 in the F sub third.
How about the other evidence that the two affidavits referred to by your adversary that was newly discovered? Why does that not qualify?
Two responses to that. First, the district court did not make any findings with respect to whether it could have been discovered with due diligence, but even putting that aside, the district court, when it discussed this evidence, in alone said that it was not overwhelmingly persuasive, and that only in combination with the serological evidence passed sort of the preponderance showing that there would be a different result at trial. So those two pieces of evidence are also not alone sufficient to satisfy 44010(1)G. I'd also like to discuss Mr. Emery's references to police misconduct that he went on at length. I just want to be clear that those allegations may give rise to a civil rights claim against the city, and that there are multiple tools for compensating wrongly convicted persons, but those allegations are not relevant to the 8B claim that we are considering here. So based on the fact that there are no showing that he could have, there's no showing concerning the diligence in the district court opinion itself, and the district court expressly rejected that finding, Bryant cannot establish an enumerated ground under 8B, and this court should affirm the Court of Claims dismissal of Bryant's claim. And that result is not unjust, again, because there are several tools for compensating wrongly convicted persons, and the legislature, as an abrogation of sovereign immunity, which must be strictly construed, determined that this was not one of those situations where compensation is available from the state.
Thank you. All right, counsel, you have 2 minutes on rebuttal.
Thank you, Justice Daniel. Justice Manzanet. I think I would ask this court to take a step back, to think about, to look at the cases, Turner, Bobby Ali, Coakley itself, and understand that this statute has a purpose that was set forth in the Law Revision Commission when it passed the statute. The statute was to compensate people who were wrongly convicted and who could show by clear and compelling evidence they would do so, and could only make that showing upon certain gatekeeping functions.
Sir,
Well,
I agree with you on your summary of the purpose of the law, but didn't the Law Revision Commission also, as part of its proposal, it did not have any predicates for the vacatur of the judgment of conviction. And the legislature subsequently, armed with the Law Revision Commission's report, nevertheless passed the current version that we see of 8-B that does have the predicate, there's a necessity for a predicate for the vacatur. I mean, isn't that a suggestion that supports the state's position that in line with the waiver of sovereign immunity, we have to strictly construe this and give that, meaningful effect to the statutory language?
I think it's very easy in this case for this court to summarily affirm on that technicality. I don't think there's any question that one could, but if one looks at Turner, Bobby Ali, Coakley, and one looks at what the courts have done with what Coakley said is an ambiguous statute, to say the least, and you implement its purpose in the case of somebody who was falsely and horrendously falsely convicted and put away for 43 years and deserves the appropriate damage remedy of the state, you will step away from the technicality and you'll do justice in the case. And it's not just doing justice by ignoring the law. You're not ignoring the law. The law supports this under Turner, under Coakley, under Bobby Ali. If you look at those cases, you have the discretion and the right to interpret this statute that in a way that manifests that its purposes are manifest. And the purpose is exactly this case. There's probably never been a more horrendous false conviction or horrible injustice to a human being to take away from 17 to 60 of his life. He gets out when he's 60 years old only because Judge Sweet understands what happened here. And it seems to me that this case cries for justice from this court, and the court has the grounds to do it. The court has the grounds in the case law that looks at this ambiguous statute to give it the grounds. Finally, I'd say that the point about the 4410 criteria, Justice Higgett, is that that criteria is set forth, as you know, for vacating convictions. In this case, it's referred to at 8B3 as the gatekeeping function. I do not believe that this court has to have the same degree of rigorousness for the gatekeeping function that allows us to go forward and prove by clear and convincing evidence. The burden's still on us. We're going to have to put a trial on to show that David Bryant was completely innocent, which we can do easily, but we have to get to court to do it. And that possibility, I think, exists only because Baba Ali, Turner, and cases give you the right to do justice in this case.
Thank you so much.
Thank you.
Thank you.
In Spirit Development versus GMF 157 LP, Mr. Klein, you have 6 minutes.
Good afternoon. Karen Klein from Olshan from Woloski LLP, counsel for appellants. Appellants here are appealing 2 portions of the trial court's decision. First is its failure to dismiss plaintiff IDC's claim against the Palizzado defendants for tortious interference. And second is its dismissal of GMF's third-party claim for fraud against Mr. Chisi. With respect to the tortious interference claim, IDC argues that they have pled, in effect, 3 types of tortious interference claims: a claim for tortious interference with prospective economic advantage, a claim for tortious interference with certain unspecified subcontractor agreements, and a claim for tortious interference with a contract between defendant GMF and IDC. With respect to the tortious interference with prospective economic advantage claim, that claim fails because IDC has not identified a single third party whose relationship defendants allegedly interfered with. IDC also has failed to allege wrongful means and in fact specifically alleged
Counselor, can we go back to something more basic? Can the Palazzano defendants tortiously interfere with the contract if they're acting as agents of the principal here?
No, they cannot. And I think that goes to the contract between GMF and IDC. And the answer to that is no, they cannot. And IDC, in fact, specifically alleged that when GMF terminated the contract with IDC, it did that through an email from the Palazzano defendants. And the Palazzano defendants emailed saying, we are terminating this contract on behalf of GMF. And the law is clear that you cannot be liable as an agent for interfering with a principal's contract when you're acting on behalf of that principal.
And with respect to this contract, Counselor, were the Palazzano defendants acting as the agents, and were they acting within the scope of their authority?
Yes, Your Honor, they were. That's alleged in the complaint, and it's alleged in the complaint. It's clear from the complaint because the complaint specifically alleges that in the email terminating the contract, which is alleged to be the breach of contract, the Palazzano defendant specifically said, we are terminating this contract on behalf of GMF. We've also put in the record the contract between the Palazzano defendants and GMF, which shows the scope of their authority and that these actions were within that scope. In addition, the economic interest defense would bar that claim because under the economic interest defense, the Court of Appeals in the White Plains Coat and Apron case held that a defendant can raise an economic interest defense where there is a managerial contract with the alleged breaching party. Here, that contract is in the record. The Palazzano defendants had a contract with GMF to provide management and other services with respect to the construction project at issue. That covers the issue of the breach, the claim for breach of the tortious interference with breach of the contract between GMF and IDC. With respect to tortious interference with the contract, with the alleged contracts with subcontractors, that fails for the additional reasons that they don't identify a single subcontractor. They don't identify the subcontractor agreements. They don't identify the portions of the subcontractor agreements that were breached or how they were breached, and that is fatal to their claim. Now, moving on to the fraud claim against Mr. Chisi, the trial court dismissed the fraud claim on the grounds that Mr. Chisi was acting in his corporate capacity on behalf of IDC when he certified the fraudulent invoices. However, this court and the New York Court of Appeals have held repeatedly that corporate officers may be liable in their individual capacity for actions taken as an officer or director without piercing the corporate veil.
But what does the fraud relate to here? Doesn't it relate to the breach of contract?
No, Your Honor. It relates to the invoices that were submitted that contained false.
But the invoices, hold on. Don't the invoices arise from the contract?
They relate to the contract, Your Honor, but that does not bar the claim. The courts have made clear that a fraud claim can proceed side by side with a breach of contract claim, and they're not duplicative.
But there's more to the claim. It has to be, you have to allege an independent duty, for example. What is the independent duty other than what you're saying is with respect to the invoices, the certifications, which seems to me is part of the contract claim?
Your Honor, thank you. So Mr. Chisi individually was required to make accurate statements. In making the misstatements, he breached the contract. And I'll point the court to this court's decisions, for example,
So he breached the contract, and you're entitled to contract damages if you establish it.
IDC breached the contract, but Mr. Chisi committed fraud when he lied affirmatively about things that he knew were false. And I'll point, for example, to this court's decision in the Friedman case, where the court found that fraud claims were independent of a breach of contract claim, where the defendants, like here, were deliberately concealing amounts that were being paid or received. Even though there were payments happening under the contract separately, you can't also make material misstatements even if it relates to the contract.
All right, you'll have time on rebuttal. Okay, we're out of time.
Thank you.
Okay. Mr. Moore, you have 6 minutes.
Good afternoon, Your Honors. Derek Moore from Bailey Duquette on behalf of In-Spirit Development, who I'll refer to as IDC, the respondent appellant, and Mr. Chisi, the third-party defendant respondent. Just want to briefly respond to opposing counsel's arguments, and then I'll get into our affirmative part of our appeal. With regards to the tortious interference claims, I want to clarify something opposing counsel said. She said that the contract they showed was between the Polzau defendants, meaning all three, and GMF. The contract is only between Polzau Development and GMF. There are at least two more defendants that we do not have a contract for, and we are not clear necessarily on whether, in fact, they were agents throughout the process. And this is similar to her statement that the email came from the Polzau defendants that that terminated IDC. That email was from one of the Polzau defendants. So there is at least a question as to whether they were agents throughout the entire course of the project.
So what are you saying? I'm sorry, counsel. What are you saying they are if they're not the agents of GMF?
I'm responding to the fact, Your Honor, that just because that effectively opposing counsel agreed with you that because they were agents, they couldn't tortiously interfere. I'm questioning whether.
So you're disputing whether they're agents. That's your position.
Correct.
And counsel, this is Judge Scarpillo. What's your factual allegation that would support your claim that they're not agents? What's your facts? What facts is that based on?
Yes, Your Honor. I mean, there's two things. One is that we do question in the complaint whether.
No, I'm not. I don't know what you're questioning. I just want to ask you what facts you're basing that on. What did you plead?
We pled in our complaint that 3RE was, we're not sure whether they're even capable of doing business in New York, whether they were actually a New York entity at the time. And what second,
facts, let me just cut you off quick because I know you have short period of time. I just want to, you have an allegation. I'm asking you, what is that based on? What facts did you plead that based on?
I think those allegations are based on what's in Mr. Chisi's affirmation, where he states that they were using economic, they were sort of forcing IDC in their in a meeting they had regarding one of the change orders. They were making economic they were forcing them to, I apologize, Ron, I'm not saying this correctly.
It's okay. Let me ask you a different question. What are your allegations concerning, what companies are you saying, what subcontractors or whatever, what allegations are there with respect to tortious interference with prospective economic relations? What companies did you plead on that?
We don't plead any specific
and that's a requirement, right? You got to plead it to make out a claim.
We did plead that there are in fact companies, but obviously. Yeah,
but that's not by the law in New York, at least in this department, is you have to make some specific allegations. So I'm asking you, did you make any?
On the business relations, correct. We don't plead specific, but we do plead that there are subcontractors, and obviously IDC is aware of the subcontractors. They did not necessarily have that specific information at the time.
Well, you would be aware, right? You're the only one who would know that information. So if you knew which companies that had that problem, you would have been able to plead it, right? Nobody else knows it. You know it.
I'm not sure if I agree with that, because they were told by third parties, not necessarily the subcontractors, that there was correspondence back and forth and that there was direct correspondence between GMF and the subcontractors. Whether we're specific ones, we're not 100% sure. And that's why discovery is necessary, to be able to figure out who exactly there were. If I can quickly move on to the fraud claim, I want to state directly that the fraud certainly arises directly from the contract here. GMF's own pleading states that the certifications were done because of a contractual requirement. And the case Friedman, the opposing counsel cites, there were clearly independent allegations away from the complaint in that case. So that case is not applicable here, where all of the allegations are based upon the contractual requirements. If I may briefly move to the our negligence claim, the court improperly dismissed the negligence claims. We state here that because of the allegations we put in the complaint, including that Mr. Polizato was the final decision maker on the project, which we also added as part of the Chisi affidavit that we submitted as part of our motion.
Counsel, what's your best case that would support that you can claim negligence on a breach of contract? What's the best case for you?
I would say the best case, I believe, is
Solmer case. Solmer.
I believe that's probably the correct case, Your Honor. Yes. I believe that's,
Solmer. But Solmer is really a different case, isn't it? But it was a catastrophic event, and isn't this really more breach of contract stuff?
I agree that love has breached the contract. What I will say, Your Honor, is that in this situation, because Mr. Polizato was so involved, and we plead that he was so involved, not only just as this owner's rep, but he actually dictated what the design team and the architects did. He was more involved, and we need discovery to see exactly how involved he was as to whether he had a duty to IDC.
What's the duty based on? What's the duty based on?
I would say the duty is based on the fact that he is a professional that is doing work as part of a construction project, and being a professional could subject you to tort liability if you're not exercising reasonable care. In this situation, when he came onto the project and claimed,
but why don't you have a straight breach of contract for that? Isn't that a breach of contract? You're saying there were unreasonable design changes and we weren't compensated properly because of Mr. Polizano's actions. But that gives you a perfectly valid breach of contract, right?
I agree it's a perfectly valid breach of contract. I would also say that there is a question as to whether Mr. Polizato was acting, individually or unreasonably within his own scope. I mean, you can be an agent for a principal, but if you do your own negligent acts, you can still be found negligent. And I believe here thank you, Your Honor.
All right. Ms. Klein, you have 1 minute.
Thank you. Just briefly, with respect to the agency issue under tortious interference, IDC specifically pled that that 3RE was effectively a DBA for Polizato Development, that they were operating under that name, and he pled that Mr. Polizato was the principal for Polizato Development. There is no question that was pled in the complaint as to agency and in what capacity they were acting. Briefly, with respect to going back to the fraud claim, we disagree that there is duplication. Again, in the Friedman case, there was a breach of contract claim and the fraud claim that proceeded in tandem. We think it's sufficiently similar, as well as the Cohen case, in which case there was a claim for fraud that proceeded based on false and inflated purchase orders, notwithstanding additional claims that proceeded side by side based on the misstatements in those purchase orders.
Thank you so much. We are out of time.
Okay, thank you, Your Honor.
All right. Gould versus OTG Management. Ms. Pecknick?
Yes, good afternoon, Your Honors. Good afternoon, Your Honors.
Good afternoon.
This is an appeal from a decision on a motion to dismiss defendant Eric Blatstein, which was denied by the lower court.
Was it a motion to dismiss or was it a motion for summary judgment?
I believe it was a motion to dismiss. No, it was a motion for summary judgment. I apologize. Excuse me. This is a personal injury case where
are different,
Yes, I'm aware. This is a personal injury case wherein plaintiff was a patron at Five Steaks Restaurant in the JetBlue terminal over at JFK Airport. She was exiting the airport to reach a flight when a busboy carrying a basket of dishes and glassware drops the basket. The dishes shatter, striking her leg, in particular her ankle. OTG runs and operates this particular JetBlue terminal as well as other terminals across various
Is there
airports.
evidence in the record, this is Judge Mazzarelli, as to what caused the person to drop the basket?
The allegation by plaintiff is that the basket was overloaded with dishes and glassware. As I said, OTG runs and operates this particular terminal as well as various terminals throughout various airports nationally. And the more relevant fact here at issue is that Eric Gladstein is the CEO of OTG.
Okay, so can you ask me it's a motion for summary judgment. How have you made out a prima facie case in order to grant you summary judgment?
There's black letter law that says that a CEO cannot be held personally liable for a tort.
Is there anything from is there an affidavit from the CEO?
No, there was not an affidavit from the CEO, but we cite to the comptroller case in our papers, which states that an affidavit of an attorney on a motion for summary judgment is based on documentary evidence in the attorney's possession. It may have probative value and should be evaluated by the court.
But
in that
there's no
comptroller case,
Go ahead.
in that comptroller case, the second department held that the special terms construction of CPLR section 3212B was too restrictive and that the affidavit of plaintiff's attorney that was based on documentary evidence in his possession was sufficient. And here the documentary evidence is
Counsel, what documentary evidence did you submit?
that Eric Gladstein is the CEO. It has not been contested.
You submitted that as what? What piece of paper did you submit?
There was no piece of paper.
An affirmation. So, I mean, I think we all agree that an affirmation, an attorney affirmation, which attaches documents or evidence is okay. I'm asking you, what did your attorney submit?
That the evidence
as
is
the
that
evidence.
The evidence is that it is confirmed and not contested that Eric Gladstein is CEO of OTJ.
How is it confirmed? Because a lawyer says that?
Plaintiff's counsel even concedes that he is the CEO.
I'm just asking you, but it's not the plaintiff. The plaintiff can do nothing, right? We all agree. It's your burden. So what did you put forth other than your attorney's affirmation, who doesn't have personal knowledge? He's not the controller of that company. He doesn't know anything about that company. Your attorney didn't put forth the certificate of incorporation, didn't put forth anything else. It's always your burden.
There were records attached to the motion establishing that OTG, then that Eric Gladstein was the CEO of OTJ. It's in the record.
Okay. So the plaintiff says that he negligently trained this busboy.
Correct.
Right?
The allegations.
That's the allegation.
Right.
And is there anything? Did your client put in anything to dispute that allegation?
No, they did not, Your Honor. But
You didn't put anything saying I'm a busy CEO and I train busboys?
Plaintiff's allegations are basically only those that are contained within his summons and complaint and the bill of particulars, which are too general for them. He needs to submit more evidentiary facts to support the allegation that.
Except it's your burden on the summary judgment motion, right? You didn't make a motion to dismiss on 3211A7.
He also relies on a blanket statement that purportedly was made by Mr. Gladstein that he's a hands-on CEO. That's the only basis to establish that he trained. He did not submit anything to establish that he individually trained.
Let me just ask you again, on a summary judgment motion, your burden first, right?
Yes.
He doesn't have to do anything until you meet your burden.
And we did meet our burden by establishing that Eric Gladstein is the CEO of OTG, and under the black letter law, he cannot be held personally liable unless to be shown to be participating in the commission of a tort, which has not been established.
And that's what the plaintiff alleges, that he was the guy who trained him. I mean, it could be the craziest allegation. The plaintiff alleges it, and your guy didn't refute it in any way, shape, or form.
We also cite to a case, S.J. Kaplan Association, which says that the burden upon a party
Counsel, I'm going to stop you. You're out of time. You'll have time on rebuttal. And please address the issues that are being put forth before the court. Okay?
Sure.
All right. Mr. Gould, sorry. You are muted, sir. Unmute.
Good afternoon.
Good afternoon.
Can you hear me?
Yes, we can.
I'm
you may
sorry.
proceed.
Good afternoon, Your Honors. I'm Robert Gould, Robert D. Gould, PC Law Firm. 244 Lakota Drive, Denver, New York. And I represent the plaintiff, Sheila Gould, who was this is the case of a lovely grandmother on the way to Florida to see her grand that has some time and becomes a patron.
Counselor, this is Judge Singh. Why should the CEO be at this point held in the case?
The CEO should be held in the case for many reasons, some of which I think the judges of your bench just put forth. So I certainly don't need to add too much to that. I think Judge DeAuguste's order absolutely speaks to that point. His order is clear. And I don't even know why we're here, because Judge DeAuguste said this was not final.
Let me just ask you, Mr. Gould, this is Judge Scarpula. What's the basis of your allegation? What's the factual basis of your allegation that the CEO of this several restaurants trained this busboy? What's your factual basis?
Okay, our investigation documents in my file. We spoke before the action ever was filed or proceeded with. We spoke with people who referred to Mr. Blatstein, who referred to Mr. Blatstein as the owner of the restaurant. That he worked in the restaurant, that he was a hands-on manager of the restaurant, that he trained people. All of these, this information is.
I think,
what
counsel,
what
my colleague is asking is, what's the basis for those rather broad claims?
The basis is what's in our file from our investigation before the case was even filed.
Okay. All right, Ms. Picnic, you have 1 minute. Thank you, Mr. Gould.
Thank you very much, judges.
Ms. Picnic, you have to unmute.
Sorry about that.
No problem.
Just to go back, we cited a case in our brief, S.J. Capellen Association, which provides that the burden upon a party opposing a motion for summary judgment is not met merely by repetition or incorporation by reference of allegations contained in pleadings or bills of particulars, verified or unverified. Some evidentiary facts are required.
Counsel, your problem, though, is that before the opposing side has to come forward with any evidence, you have to meet your burden.
And it's our position that we didn't.
And the lack of an affidavit by the CEO, that's all that he needed to do, is submit an affidavit saying, I'm not the one who does the training. I hire a company to do that. But we have nothing.
We also cited the case Doe versus Bloomberg, which was a sexual harassment case where Mr. Bloomberg was named directly as a defendant, and he filed a motion to dismiss with a motion for summary judgment with no affidavit.
I was on that case, and the opposition papers there submitted sufficient evidence to establish a prima facie case.
But Mr. Bloomberg was dismissed from
they had enough in their papers to go forward. So what I keep saying to you is that had there been an affidavit here from this CEO, we wouldn't be here.
Or someone with personal knowledge about the facts. It doesn't necessarily have to be the CEO. I mean, it's the attorney. All the attorney can do is say, these are the documents, consider these documents, which we would. But don't you think you need a little more than that?
I disagree. I think that we have met our burden. It's uncontested that he's the CEO. And again, I go back to the Doe case where there was no affidavit submitted on behalf of Mr. Bloomberg, and yet he was still dismissed from the case. So therefore, the same should apply here.
Yeah,
but that was that a pre-answer motion to dismiss?
It may have, I believe it was a pre-answer motion. It was a pre-answer. 3211A.
That's exactly it. You didn't make a pre-answer motion to dismiss in which you could have said the complaint doesn't state a claim. You made a motion for summary judgment, and 3212 requires certain things on that, which we don't require on 3211. I guess that's all of our points.
All right, and we've got your arguments. Thank you so much. We're out of time.
Thank you.
Platt versus Berkowitz. Ms. Platt, you have 3 minutes.
I don't seem, oh, here I am.
Ma'am, if you're speaking, we can't hear you.
Oh, I didn't know I was supposed to speak. I'm here.
It's, yes, you are first.
Okay. Good afternoon, Your Honors. May it please the court.
Shut me down. Let's go. Give me my
Hold
phone
on
back.
one moment. Mr. Gould, you are still live. I need you to exit the platform since your arguments are over and your mic is on and you're interfering with the next argument, sir. Thank you. All right. Let's try this again. Ms. Platt, you may proceed. You have 3 minutes.
Good afternoon, Your Honors. May it please the court. This is an appeal from a decision which dismissed my complaint. The complaint contained all elements needed to state a cause of action for a violation of Judiciary Law 487. The deceit prong in the complaint described 37 separate instances of material falsehoods, along with evidence that these deceits were made with knowledge of their falsity. The decision didn't address whether or not the cause of action was sufficiently stated. It focused entirely on the alleged offenses of the defendants. As to Defendant Berkowitz, the decision said, and I'll quote, that I'd had opportunity in the prior action to litigate whether Berkowitz had made false representations. But this court's holding in Melcher versus Greenberg Prague made it clear that a Judiciary Law 487 claim may be brought in a separate proceeding where, as here, no prior order is sought to be overturned or modified. And there can be no collateral estoppel barring the instant claim because there has never been a determination made as to the truth or falsity of Berkowitz's alleged deceits. As to Defendant Kaplowitz, the decision said that I had no standing to sue her because she was not counsel in the case in which I was a party. While this is a requirement for the attorney who makes the deceits, this is not a requirement for the attorney who colludes with the deceitful attorney. On point is the case of Knopf versus Esposito, where a party's general counsel who did not appear in any litigation was found guilty of colluding with the party's trial counsel in violation of Judiciary Law 487. The motion court awarded sanctions against me for making the complaint. But this court in LaRusso versus LaRusso asked that there be some showing of bad faith before sanctions are imposed. In Wheel versus Stensler, the court held sanctions ought not to be imposed in such a manner as to restrict ultimately unpersuasive yet good faith arguments requiring a review of existing law. At all times, I have proceeded in good faith with the sincere belief that a substantial wrong has been done, and with the fervent hope that this court would provide a remedy. Therefore, I pray that this court will reinstate the complaint, remand the case to a different judge, and vacate the sanctions order. Thank you for your time.
Thank you so much. Counsel for Berkowitz, you have 3 minutes.
Good afternoon, Your Honors. David Salhanek for Respondent Berkowitz. This is appellant's fourth attempt to raise essentially the same claims of fraud and deceit against Berkowitz. The 3 prior attempts were unsuccessful before Justice Schechter in the Supreme Court. First, this is record page 252. Ms. Platt, in the Windsor action, which is the underlying action that Ms. Platt is speaking about, tried to interpose a claim for fraud on the court. That claim was rejected by Justice Schechter, who said it failed to state a cause of action. Ms. Platt tried again. She filed a motion to vacate the injunction against her for disclosing attorney-client privileged information based again on alleged fraud on the court by Berkowitz. In the record 277, 278, Justice Schechter said her arguments are not based on anything that either was not or could not have been raised in the course of the proceedings or her appeals. Even more important is the fact that Ms. Plant divulged privileged information. That wasn't enough for appellant. She tried a third time in front of Judge Schachter by filing a motion for sanctions against respondent Berkowitz. And if you look at Judge Schachter's order, it's page record 276. And I think Judge Schachter's bold and underlining in the order speaks to her frustration about this third attempt to raise the same claims. Judge Schachter said the court is not convinced that any judges were fooled or prejudiced into issuing orders. This is now Ms. Platt's fourth attempt to raise the same claims of fraud or deceit. And those claims are barred not only by collateral estoppel, because Judge Schachter's order on page 276 of the record finding that the court was not prejudiced or misled bars her claims for Judiciary Law 487, a cause of action under Judiciary Law 487, because an injury proximately caused by the fraud and deceit must be shown. And Judge Schachter determined finally and definitively that that could not be shown. But further than that, Ms. Platt, the appellant, admitted, and this is page 199 of the record, admitted to divulging privileged information, begged for forgiveness from the trial court, and Justice Moulton's order, original order, which enjoined Ms. Platt, the appellant, was based on his personal review of the documentary evidence that Mr. Berkowitz had introduced into the record. So it wasn't based on anything that Berkowitz had represented in an affidavit. It was based on documentary emails, which were appended to Mr. Berkowitz's affidavit that Judge Moulton reviewed in detail and carefully. This is record 214, 215 of the order. Now, with respect to the sanctions issue, Ms. Platt says she proceeded in good faith here, although this was her fourth attempt, and really her fifth attempt, because Judge Bluth, 203, 207 of the record, rejected Ms. Platt's separate lawsuit for indemnification arising out of her claims in the Windsor action.
Thank you. We're out of time. Wrap it up. I'll give you another 30 seconds.
Okay. Record 196-201. Respondent Berkowitz gave Platt the opportunity to withdraw her claims in the action. He warned her that they would be sanctionable and were privileged. She refused to do so. She tried for a fourth time to raise the same claims. Sanctions are proper, and they were properly awarded by Judge Kotler in the Supreme Court. Thank you, Your Honors.
Thank you so much. Counsel for Ms. Koplowitz, Mr. Brown, 3 minutes.
Yes, thank you, Your Honor. Grant Brown of Anderson Kill on behalf of Respondent Deborah Koplowitz. The Supreme Court correctly dismissed the Section 487 claim and conspiracy claim against Ms. Koplowitz, sanctioned Ms. Platt, and we ask that this court affirm. The 487 claim is not properly asserted against Ms. Koplowitz because Ms. Koplowitz was not an attorney of record in any case involving Ms. Platt. The court recently reiterated this standing requirement in its decision in Mazzocchi versus Gilbert in 2020. That case involved some of the same parties. Mr. Mazzocchi sued Ms. Koplowitz, said that he acted deceitfully in an action with her. Mr. Mazzocchi also sued Mr. Berkowitz and said that he colluded with Ms. Koplowitz to allow the deceit to occur. And this court affirmed the dismissal of that complaint on the pleadings. And with respect to Mr. Berkowitz, ruled that because he was not an attorney of record in any action to which Mr. Mazzocchi was a party, he could not sue Mr. Berkowitz under Section 487. The same logic applies here. Ms. Platt sued Ms. Koplowitz for collusion, but Ms. Koplowitz wasn't an attorney of record in any case involving Ms. Platt, and so the case should be dismissed. But even if Ms. Platt had standing, she hasn't alleged a Section 487 claim against Ms. Koplowitz. Section 487 requires that there be a deceit or collusion with the intent to deceive, and it must be egregious conduct. In Sean v. Ellis, the court held that bringing a baseless defamation claim didn't warrant 487 liability. In Struenvasser v. Zeiderman, the court held that switching pages in a document to obfuscate data was not sufficiently egregious to warrant liability. Here, all Ms. Koplowitz was alleged of doing was taking discovery, sharing that discovery with general counsel for her client, and that's it. She wasn't alleged to have altered any of the documents or anything like that. She just took discovery. That's a normal lawyerly activity, nothing deceitful about it, and it can't support a 487 claim. Ms. Platt also sued Ms. Koplovitz for conspiracy, saying that Ms. Koplovitz conspired with Mr. Berkowitz in his purported misrepresentations. Well, that's what she's alleging on appeal, actually. Below, in front of the Supreme Court, she argued that the conspiracy was to take discovery in violation of the CPLR. But that obviously failed because violating the CPLR isn't a tort. So she changes the theory on appeal and says she conspired to violate Section 487. But she doesn't, Ms. Platt doesn't allege Ms. Koplovitz agreed that Mr. Berkowitz would make any misrepresentations, and that's required. There needs to be an agreement to do a tort. And because that's not alleged in the complaint, we submit that it's not properly brought. Lastly, we hope the court affirms the Supreme Court's award of attorney's fees. This case was frivolous. Ms. Platt says that it's a fraudulent claim that was brought against her, but she herself admitted that she breached attorney-client privilege. It wasn't a fraudulent claim. It was supported by her own admission. And now she's suing Ms. Koplovitz, who had no appearance in the claim whatsoever.
Thank you so much.
Thank you, Your Honor.
Thank you. All right, Ms. Platt, you have 2 minutes, ma'am.
Thank you. There were 3 times that I attempted to bring Mr. Berkowitz's falsehoods to the attention of the court below. In every case, they refused to consider it. In the first motion, they said that it was immaterial to the ultimate determination, therefore they wouldn't consider it. In the second one, they applied something akin to latches. They said I was too late to raise this argument, and therefore they wouldn't consider it. And in the third one, which was an action for sanctions, Justice Schechter said, I'm not convinced that any judges were fooled, therefore I don't have to go into whether there was truth or falsity in the statement. I don't think that's the standard for sanctions, but the point is that there was never a determination of the truth or falsity of Mr. Berkowitz's statements. I keep trying to get it. I'm hoping that this court will bring this about. There in Knopf versus Esposito, there was a prior action for sanctions which was denied because there was no plausible injury pleaded. When they brought a 487 claim and an action and a defense of collateral estoppel, the judge held that this was not a collateral estoppel because the issue of truth or falsity wasn't considered and it wasn't fully litigated.
Okay, I think we are out of time now. Thank you. We have the papers and your record. Have a good day.
Thank you. Thank you for your time.
You're welcome. People versus Rafael Rosario. Mr. Zeno, you have 6 minutes.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Rafael Rosario. May it please the court. The evidence did not prove beyond a reasonable doubt that Mr. Rosario was the driver of the car that ran the red light leading to the officer's injuries. And even if it was sufficient to prove identity, it was not sufficient to prove that the driver acted with criminal recklessness. The car was owned by the mother of Mr. Rosario's child, with whom he resided in the Bronx at the time of the accident.
In what way, Mr. Zeno, this is Judge Mazzarelli. Good afternoon. In what way wasn't it sufficient to prove that he acted with sufficient recklessness? We want to concentrate on that for a second.
Sure, I will jump to that issue, Your Honor. Recklessness ordinarily requires risk-creating conduct plus an awareness of that risk-creating conduct. For example, in Asaro, the sort of leading court of appeals case on criminal recklessness by a driver of a car, the party who was found to be reckless had driving down a street, had previously been warned about a dangerous turn, had a passenger in the car that was warning him to slow down, and notwithstanding those
counsel, on the facts here, it is alleged that the driver of this vehicle ran a stop sign and barrels into a police vehicle in a T collision at a high rate of speed. And we know that in New York City limits, the speed cap is 25 miles per hour unless otherwise stated. So how is driving in excess of that, and as I understand it, the accident reconstruction surmised that he had to be traveling between 45 to 60 miles per hour and running the stop sign. Why are those two facts not enough?
Right. So I think the reconstruction expert said between 47 and 50 was
Okay.
the likely speed, and he did run through a red light. But that's a traffic violation. We have no evidence about what was happening before he got to that red light. It's reckless in the colloquial sense that as
Counselor,
a
this is
driver on
Judge
the
Singh.
road,
Counselor, this is Judge Singh. Were there lights on the undercover car on?
there's conflicting testimony about that, but taking the evidence in the light most favorable to the people, one of the officers said the lights were on, but there was no evidence that those lights could be seen in sufficient time.
What time of night was it?
It was 3:30 a.m.
Well, so wouldn't that be a time that probably lights would be seen from more?
Well, there was no evidence as to whether there were cars blocking that would have blocked it. There's no question that the driver of the car was speeding and violated at least two traffic laws. He went through a red light, or she went through a red light, depending on who it was, and speeding. But those are ordinary traffic infractions. Criminal recklessness requires something else. If every time someone went through a red light in excess of the speed limit, they were reckless criminally, then everyone who does that, regardless of whether there's an injury, would be guilty of reckless endangerment, which is an A misdemeanor, subjects them to a year in prison. So going through a cutting a light, which it's clear from the testimony that it had just turned red, maybe ran a yellow light, thought he could make it. Everyone who does that in the city of New York, who's exceeding the speed limit, is guilty of a Class A misdemeanor. And that's just not the law. The law is to be criminally reckless, there needs to be that violation of the law plus something else, plus some special awareness, some warning that what you're doing is inherently dangerous. To elevate it to that blameworthiness for a crime, and if there had been no injury here, it still would have been an A misdemeanor under the DA's interpretation of this law. Everyone out there violating two traffic laws that creates a risk is guilty of an A misdemeanor, and it's tragic that this accident occurred and there were 3 serious injuries. We're not discounting that, but that should not drive the determination of whether there was reckless conduct here.
Okay, can you address the issue of the DNA evidence and the sufficiency of it?
Sure. The proof rested here that my client was the driver rested entirely on DNA evidence. He was a regular driver of the car with the mother of his child, who was the owner of the car. When the police got to the car, no one was in it. The DNA evidence presented in the light most favorable to the people came through their expert. She could say no more than that it was likely that the major contributor of the DNA on the airbag was the driver. There were approximately 10 skin cells, which are 58 trillionths of a gram of DNA material on the airbag, contributed by at least 3 people. Ms. Judge Scarpula, you're muted.
I see that. Didn't your expert concede that the defendant was the major contributor of DNA?
Yes, absolutely.
So, okay. So both sides agree. He's the major.
Yes, but if there were 10 skin cells, that only means 4 of them came from him. 3, there were 2 other contributors.
No, I thought you just said that she testified something that your expert didn't agree with. Everybody agrees. He's the major contributor.
I'm saying taking their expert at the expert's word, all she could say was that it was likely that he was driving based on the fact that he was the major contributor. But there were 2 other contributors. We don't know who they were. Could have been the mother of his child. The other regular driver of the car could have been someone else. There's no evidence as to that.
Is it your position that secondary DNA from the seatbelt somehow scattered or impacted and was on the airbag? Is that correct?
Absolutely. And the people introduced.
But hold on a sec. What evidence is there that there was DNA evidence on the seatbelt?
The people did not swab the seatbelt, so there was no evidence as to whether it was or was not on the seatbelt. The people did submit from their expert about airbags a video showing the deployment of an airbag, where the airbag blows up in the driver's face, and that the shoulder harness makes contact with the airbag. We know there were at least three people, who had DNA implanted on the airbag. It's just, and yes, it showed that if you accept the people's proof, that Mr. Rosario was the likely driver, but likely isn't proof beyond a reasonable doubt.
Okay, we'll hear from Ms. Wang, and then you'll have time on rebuttal. Ms. Wang, you're up.
Good afternoon, Your Honors. Diana Wang for the people. With respect to the DNA, it's simply astronomically unlikely that a seatbelt transferred more DNA to the airbag than the actual driver at the time of the accident. As the people's evidence showed that the driver at the time of the accident came into direct contact with the airbag at a rate of 200 miles per hour. The airbag went onto the driver's face, right onto their hair, right in front of their face, onto their chest. It's simply
was there an explanation in light of the evidence about the extreme force with which a airbag deploys and hits the face of a driver? Was there any explanation as to why so little DNA was found on this airbag? Was there any explanation as to that?
Not directly, Your Honor, but we did hear from the swabbing officer who said that he took a Q-tip and he swabbed the surface of the airbag, the entire surface of the airbag. So we know that he did it with a Q-tip. In any case,
and the relevance of that, I'm not sure what that means.
I believe that a Q-tip swabbing, if you take common sense inferences, that it would not pick up the entirety of the DNA that is all left on the airbag. But in any case, I think the most compelling part of the evidence
Counsel,
is that
are we supposed to assume that there was more? I mean, it seems to me it is it was their job to collect all of the potential evidence in order to, be able to establish who committed this act, and to then now argue, oh, they only used a Q-tip and therefore it probably didn't collect as much as there was on the airbag, seems a little specious to me.
Well, Your Honor, we don't have any evidence to know how much DNA should have been left by the driver's face. It could be that 10 skin cells is more than ample DNA that would be regularly left by a driver who's hit at 200 miles per hour with an airbag. But the most compelling
does your expert say that anywhere, either at the trial or in any affidavit?
No, Your Honor.
What they would expect to find on an airbag with this kind of such a severe impact that all of the airbags in the police vehicle deployed. So clearly this was a high impact accident. It just seems like there's something missing out of this expert opinion when it doesn't explain why there is only a infinitesimal amount.
Your Honor, I should add that our expert did testify that in their own OCME studies, evidence of DNA has to be vigorously scraped or scrubbed or swabbed in order for DNA testing to show up with any identifiable profile, because in his words, skin cells don't just fall off. And that's what makes the defense
Counsel,
theory.
this is Judge Scarpula. Let me just ask you, was there a dispute between the experts That there wasn't enough DNA here?
No, there's no dispute. Both experts
Did
agree.
either expert say that there wasn't enough DNA?
No, both experts agree that there's only one major contributor, that the major contributor had so much DNA left on this airbag that a full profile was able to be developed, and that the profile matched that of defendant. So there is no real conflicting testimony. And we know from our expert, to your question, Judge Manzanet, that OCME studies have shown that in order to get DNA testing at all, you have to vigorously swab or scrape it off, because skin cells don't just fall off and shed onto surfaces like that.
Well, perhaps the violence of a car crash could lead to skin cells coming off or otherwise shedding from the body.
Yes, but the point is, who is more likely to have left DNA that will contribute to the major contributor? The driver that came into actual direct contact with the airbag, or someone who drove the car previously, shed some DNA on the seatbelt, and then the seatbelt somehow transfers or deposits DNA onto the airbag, and does it so much so that it overwhelms the actual driver of the accident? That is the question the jury was faced with, and that was the question that the jury decided. And with respect to the recklessness, it goes without saying that defendant was driving on a residential street at a rate of 50 miles per hour. There was also evidence that he did not brake at all before the crash. And he ran past a red light. The police cars was right in the middle of the intersection, and there was no conflicting testimony about whether or not the lights were on. All three officers testified the lights were on. Only one officer testified it was the strobe lights that were on, and the other two did not specify which lights were on. But we have testimony.
Counselor, I'm sorry. Can we go back to the DNA evidence? I want to. Your adversary says essentially that your witness testified that it wasn't likely that there could be that secondary transfer onto the airbag. Is that a fair characterization of the testimony of your witness?
Your Honor, I want to be specific here. Our expert was asked, isn't it reasonably possible that the seatbelt transferred the DNA? And our expert said, it's possible. Now, I read that on the cold transcript to mean, no, it's not reasonably possible, it's possible. A layperson, especially a scientific layperson's understanding of what's likely or what's possible is not the same as what a lawyer's understanding is. I think as lawyers, when we hear more likely or less likely, we think preponderance of the evidence. But when a scientist says it's possible, when asked, is it reasonably possible, I think that means I'm leaving room for that possibility, but based on all the evidence I've seen, based on the studies that I've seen where DNA has to be vigorously scraped off in order to leave a DNA profile, that's just not likely.
But going in her testimony as a whole, were there other parts of the testimony where she characterized this issue in other ways?
No, Your Honor. Our expert said that it was unlikely or less likely that any DNA was transferred from the seatbelt. And even the defense expert admitted that she cannot say if any DNA was transferred from the seatbelt to the airbag, let alone so much DNA that it overwhelmed the DNA left by the driver. And if there are no further questions, we would ask the court affirm.
Was there any evidence that it's possible for a airbag to hit someone's face and not leave any DNA in light of how little there was found here?
I do not believe there's any testimony on that, Your Honor, and I would dispute whether or not the amount can be counted as little. We know that 10 skin cells is objectively a very little amount.
It's less than a full picogram, which is a tiny sample. There's no question. It's the smallest measurement possible.
Yes, the total mixture was 58 picograms, but I think there's a difference, and we don't have testimony on this. I agree, but I think we don't know how much DNA can be expected to be left on an airbag. But we do know from our expert that you really have to vigorously swab a sample in order to get any DNA profile at all. And in this case, we were able to get a profile, and that was defendant.
I have one more question.
Right
Is there
ahead.
any other circumstantial evidence in the car that would suggest that the defendant was the driver?
Yes, Your Honor, we have an easy pass in the car that was registered.
Well, but easy pass, I have an easy pass, I leave in the car, so that doesn't go cut one way or the other, right?
Well, I believe, Your Honor,
Come on.
with the DNA match and the fact that the easy pass and
They
credit
live
card.
together. I mean, there's no question that to me, that's just they live together. So I mean, that means nothing.
Where was the credit card found? Where was the credit card found?
It was inside the car, but we don't know where.
I'm sorry, inside the car, you said? It's just
Yes.
found inside the car, okay.
Yes.
Okay.
I agree that the easy pass and the credit cards are less compelling than the DNA, but as we will argue in our briefs, the DNA is very compelling evidence.
Okay. Thank you so much. Mrs. Zeno,
Thank
have
you.
2 minutes.
There were 10 skin cells from 3 different people. There was enough from those 3 people to identify them as separate people. That's what the people's expert said. I heard my opposing counsel argue that it was astronomically unlikely that my client wasn't the driver. The expert at trial never said that. The most the expert at trial said was that it was unlikely. The expert did not say that it was unlikely that skin cells could be transferred from a seatbelt. That's not true. She said it was unlikely that the major contributors' skin cells were transferred from a seatbelt. But we're still left with 2 other contributors. Where did they come from? It's people's burden of proof. Those skin cells got there somehow. Maybe it was from 3 people who had been driving the car and 3 people's skin cells transferred. Major contributor, when you're talking about 10 skin cells, check my math, means that maybe the major contributor had 4 skin cells and the 2 others had 3.
Counsel, this is Judge Scarpullo, did your expert argue that there wasn't enough DNA?
No, not at all. There was enough DNA.
So that wasn't an issue for anybody. Everyone agreed there was enough DNA.
Enough DNA to identify 3 separate contributors.
To be clear, my question about the DNA, again, is that did anyone testify about how much DNA one would expect to find on a hit with such tremendous force that the other vehicle had all of their airbags deployed? So it seems to me that, I don't know, just logic would tell you that the offending vehicle would have a whole lot more DNA, not that there wasn't sufficient. Obviously, both experts testified that they could profile them. That was not my point. Did anyone testify that how much one would expect to find scientifically in this kind of accident?
Short answer is no, Your Honor, and I would turn to the people's burden of proof. It's their burden of proving. And I would also note that there was a conflict about whether a seatbelt would likely transfer to an airbag, cloth-to-cloth transfer, and how likely that was to happen. I identified at 5 different places in my reply brief where the expert said only use the word unlikely, not astronomically unlikely as the people argue in their brief. And I would also point out that when the expert tried to recover the DNA from the airbag, they used a Q-tip swab, cloth-to-cloth contact, same contact that an exploding airbag would make against a seatbelt. You just cannot rule out beyond a reasonable doubt that someone else was driving this vehicle. It's just not there.
Thank you.
Were there any reports in evidence that the vehicle had been stolen?
No.
What time was the arrest after this accident? Was it on the same day?
It may have been the following. I don't know, Your Honor. I don't know the answer to that.
Okay. Are there documents in the record that would tell me at what time? We know the accident happened at 3:30 in the morning. At what time the police came to the home of this defendant, and whether there would have been time to report a stolen car, assuming they would have known about that?
Your Honor, I can answer that question if that would be okay.
I will permit it. Go ahead.
I believe defendant voluntarily gave his DNA sample 3 months after the time of the accident.
Okay, so there was never a car reported stolen, is what you're saying?
Not in the record, Your Honor.
He was not arrested contemporaneous with the accident, is that correct?
That's correct. He showed up with his lawyer and voluntarily gave a buccal swab about 3 months after the accident, and then the match was made.
Okay, all right. Thank you both so much.
Thank you.
Chang versus Phillips Auctioneers. Mr. Weldon, you have 5 minutes.
Thank you very much. Good afternoon, Your Honors. May it please the court, Matthew Weldon of K&L Gates on behalf of plaintiff appellant Zhang Chang. In this case, as you know, Mr. Zhang seeks the return of around $2.6 million from defendant respondent Phillips Auctioneers, which Phillips wrongfully forced Mr. Zhang to pay contrary to the terms of the parties' settlement agreement. And the trial court
Except sorry, your client did not fulfill his portion of the settlement agreement. Am I not correct?
He did fulfill his portion of the settlement agreement. He paid
in
26.
full. I'm sorry.
Yes.
I don't see
Yes,
anywhere
that's
in the
right.
record that he paid in full prior to the issue coming to a head.
Well, not prior to the issue coming to a head. He eventually paid in full. And
yes, but
and then some.
eventually paid in full means that he violated and breached the contract, right?
Well, he missed the payment schedule,
So
and
he
the payment
breached the
schedule.
counsel. This isn't a trick, right? The facts are what they are. If the agreement required him to pay by a date certain and he didn't pay by a date certain, there's a breach of contract. No.
Well,
Hey,
he
my
may
name
have
is
breached
John
the
Higgett. I'm
contract.
just following up my call earlier today to see if
Someone
you got
is-
the message about
someone
needing
has
to refill
a-
the Vyvanse for Jackson. Again,
Hold
his
on one
birthday.
moment.
Judge
November
Higgett.
4th.
Judge Higgett.
Oh, it's Judge Higgett. Okay, sorry. All right. I thought it was someone else. Sorry. All right, go ahead, Mr. Weldon. My apologies to you.
Yeah, it's all right. What I was trying to explain was that under the settlement agreement, it was contemplated that payments may be late, and there was an interest component built in. And so, upon late payment, interest accrued, and Mr. Zhang paid the entire interest under the agreement. And so, we do say that he did perform under the agreement in full, although he made late payments. I want to turn to the first
who's
issue.
at that time, counsel, this is Judge Singh. Who actually had title to the painting at the time that it was put up for auction?
Well, Phillips had title to the painting at the time it was put up for the auction, but
So let me stop you there for a second. So as the owner of the painting, why couldn't Phillips put it up for auction to be made whole?
Well, I think that this kind of goes to a core issue that I think the trial court was confused about. It's not our case that putting up the painting in the second auction was somehow prohibited in itself. It's the fact that after the auction, when it was determined that no one out there would actually pay more than Mr. Zhang, that Phillips decided, okay, well, let's just proceed under the settlement agreement and Mr. Zhang can pay for the painting. And at that point is when Mr. Zhang was presented with the acknowledgement form and saying, unless you pay us $2.6 million more, we are not going to deliver this painting to you.
But wasn't that additional $2.67 million one of the criteria on the sale, right? So when they put it up for sale, that was one of the contingencies to buying this painting, correct?
Well, that's also a very interesting issue, because if in fact he proceeded under the terms of bidding in the auction, and had to pay the second buyer's premium, it would follow that he would have to pay the amount that actually he bid in the second auction. And that's not what Phillips has asked for. And that would be much less than what Phillips actually received. What Phillips has said is pay us what the settlement agreement amount is, plus interest, and pay us another commission, because he already paid one commission, which was built into the sale price agreed in the settlement agreement. And so the fact that it's put up into auction and he bids on it, it's really a sham auction. What they were doing is looking for another buyer who may actually come in and buy more or pay more for that painting than Mr. Zhang was owed under the settlement
This is
agreement.
Judge Scarpula. Doesn't the settlement agreement say that that Phillips can resell the Richter work by auction, it being understood that in an event that such resale is for less than the guarantee amount, that plaintiff will remain liable for the shortfall together with all costs incurred in the resale? And isn't what you're talking about a cost incurred in the resale?
No, I don't actually think that the commission payment would be a direct cost in a resale
Well,
transaction.
okay, come on. What other cost could there be in the resale? Why, they have to hire extra security guards? Come on. That is clearly what they're talking about, the costs of the resale.
Well, I would like,
And that's what the settlement agreement says, correct? I just literally read it from the document.
Could you direct me to I'm sorry, the section that you're reading
It's
from?
Subsection 6 of if plaintiff defaulted, what could happen?
Well, I think that acknowledged that if the transaction was not going to be consummated, essentially, that he would not be able to get this painting. But under Section 7.1, what it says is that upon payment of the settlement amount, that he would be entitled to this painting. And what we're saying is there's nothing else in the agreement that says, well, if you're really willing to pay the settlement amount, that there's some right that Phillips would have to say, well, actually, you know what, you're late on your payments. And even one day, I mean, this would be true on that interpretation of the agreement. Even one day late, they could say, thank you very much. We'll take your full payment, but we have no obligation to transfer this painting to you. And so that's what our case is, really. We say under 7.1, there is a contractual right. And to your question, Mr. Singh, it's not that Phillips didn't have title to it. It's that if Phillips decided to proceed under the settlement agreement, that they had remedies in that agreement to cover them for interest. And there's no right in there to say, well, you're late on your payment, so what we want to do is charge you $2.6 million more. And if you don't, we're not going to pay.
I don't think that's what happened. I'm sorry, counsel. You breached the agreement. Your client breaches the agreement. The gallery exercised its remedies in accordance with the terms of the agreement. And as my colleague said, putting it up for sale and paying costs.
Well, but that is not a cost of the sale.
Okay.
The cost of the sale, it would be, it had to be transported somewhere. I mean, I could think because it had to be transported to London to be put onto sale. It was in New York, had to be transferred to London. That would be a cost.
Yeah.
It had to be listed in the pamphlets, and that could be a cost as well. I mean, there are costs that I can think of that would actually apply in this situation, and an extra commission of $2.6 million is not a reasonable sort of interpretation of the cost associated with such a sale. And in fact, it wasn't that they had sold it to somebody else. They sold it back. They didn't sell it because he was the highest bidder at the auction, and therefore, after the second auction, they said,
Counselor?
"All right,
Finish up because you're over your time." Okay.
sorry." Well, I just want to reemphasize that we're not talking about the putting the painting up in the second auction. What we're talking about is what happened subsequently to the second auction, where they had a point in time where they said, okay, you're going to receive the painting, but you're not going to receive it for the settlement amount. You're going to receive it for the settlement amount plus interest plus another buyer's premium of the additional $2.6 million. And at that point, they said, we have this bacon work as well, which was not even mentioned by the court in its decision. They refused to return the bacon work as well. That was also a breach of they didn't have the right to do that under the agreement as well. And so that's a really important element to this duress point as well.
All right, thank you. Nope, you're way over time. You'll have time on rebuttal. Okay, Mr. Weiner, I don't know how you pronounce it.
It's Weiner. It's Weiner, Judge.
Weiner, okay.
Dan Weiner from Hughes, Hubbard and Reed for Phillips Auction House. I'll start by answering Justice Manzanet's question. No, Mr. Zhang, the plaintiff, breached the settlement agreement. At that point, I think as Judge Singh pointed out, Phillips had a right, title, and interest and ownership of the painting. Mr. Zhang, he never owned it. He never paid, so he never owned it. So there they were, owed a lot of money. He breached the agreement, so they had the right to sell it, and they told him, we're going to sell it. And remember, his excuse is, I signed that acknowledgement that made me pay the buyer's premium under duress, as if he was forced to sign it. Remember that he had three choices, right? He could have paid what he owed before the second auction. You know, he pays what he owes, and he gets the painting, the Richter. Or he could have not bid at the auction, let somebody else buy it, and then that money would have been taken to pay off his debt. He chose the third option, which was bid at the auction because he wanted this work. But when he bid, he knew the rules. He knew the rules, and you know that from the record. I think it's page 268 and page 271. Phillips told him before the auction, if you do this, if you're the successful bidder, just like any other bidder, you're going to have to pay your buyer's premium.
So counsel, your adversary says costs don't include, the second buyer's premium. It is a little ambiguous, isn't it? Why should it include that?
But it's two responses. It's an interesting point. I don't think it was argued below about whether costs should include it. I can see it including it, but the key Justice Singh is he didn't go in unaware. He didn't know. Oh my God, I had no idea I was going to have to pay a buyer's premium. In the correspondence, in the conditions of sale, which are at page 245 of the record, it says if you bid just like any other bidder, you're going to have to pay a buyer's premium. And no one forced him to bid. No one has the right to own a multi-million dollar.
Did he have to pay the amount that he bid the second time also?
When he bid the second time, doesn't matter, right? Then he had to pay what he owed on the debt.
Right.
Right, because it can't be that he could have, remember, when he didn't pay the first time, right, he was a guarantor of a sale. That means if nobody shows up, I'll pay $24 million. No one showed up. When he didn't pay the $24 million, Phillips had to reach into its pocket and take $24 million out and pay the consignor, the person who put the work up for auction. So they were out $24 million. That's what led to the lawsuit. That's what led to the settlement. And so when they're out a lot of money, he has to pay what he owed plus interest, right? So he doesn't get a free shot.
He has to pay the $24 million plus interest.
Right.
And what did he bid the second time?
I think he bid $20 million, but it can't be that you can get away saying, okay, I'll bid, and if I don't want to pay, then I'll bid a year later.
I just want to make sure I understand one thing. Did he have to pay the additional $20 million too?
No, he didn't have to pay that too. It was just his original debt and his agreement to pay the buyer's premium. And the
based on the bid of the second bid, based on the $20 million bid.
Right, correct. Right. And the judge below said, recognizing the decisions of this court, that it can't be duress if someone says they're going to exercise the legal right. Phillips had the legal right to sell the work. And your honors have said, I think it was you, Justice Mazzarelli in the Beltway 7 case, you said there's two prongs to economic duress. One, it has to be an unlawful right. And two, even if it is, you have to be forced into doing it. And we make the point, nothing on earth forced him to do it. He could have chosen the two options, that is, don't bid and that your debt gets paid down by some other bidder, or pay off your debt before the sale.
Counsel, this is Judge Scarpullo. So basically your argument is the acknowledgement ends the case, and to the extent that the plaintiff tries to vitiate the acknowledgement, can't make out as a matter of law a case for economic distress, correct? Because you had the right to do everything you did, and plus he waited like 2 years to sue, or 18 months to sue, something like that, right?
Right. And that's
Got
right.
it.
You're right. And he has a couple of other excuses the other than the duress excuse, but you're right. But his other excuse on appeal, for the first time, he says the settlement agreement is ambiguous. And it's a strange argument because if you look at his opening brief, he has a whole 4 pages that says the settlement agreement is ambiguous. Then you look at page 7 of the reply in the footnote, it says, let's make one thing clear. The settlement agreement is not ambiguous. So my head started to hurt.
Thank you.
Until I realized he didn't raise this below at all. So
thank you so much.
Anything else? Thank you, Justice. Thank you.
Okay. Mr. Weldon, you have 1 minute.
Okay, first of all, what the defendant alleges is that there's a separate $2.6 million payment agreement, and I think that that's clear that there is no such agreement. And
no,
and
I don't think that's what he's saying. He's saying that your client was on notice that if you're going to go bid on it, that there is going to be a second buyer's premium. That's the argument.
Well, yeah, being on notice and being obligated to pay the $2.6 million, I think, are two different things. So
yeah, but then you sign an acknowledgement. You sign an acknowledgement. You don't have to sign the acknowledgement. You can come into court. There are lots of things I think you can do. Your adversary had 3 options. I can think of at least one more, right?
Well, Phillips had $18 million of his cash, the Bacon painting, which they said they were not going to return to him, which he owed $17 million to Mr. Sin for, and they said they weren't going to return that, and they said they were not going to give him the Richter painting. So he had no choice but to sign that acknowledgement. And by the way, that acknowledgement is on letterhead from Phillips Limited in London. It's not the same parties as the defendant here. I wanted to point this out to the panel because it's important. The record came through on pages 279 and 280, and there's a missing footer. When the consultants put together the record, they cut out the missing footer, and the footer says Phillips Auctioneers Limited and gives the address for that company in London. And so what you have is a letter from a gentleman in London sent on behalf of the company in London, which is not the party to the settlement agreement. So under Section 14 of the settlement agreement, there can't be a modification of the settlement agreement. So that can't be the basis for the agreement that he has to pay $2.6 million extra. I just discovered that last night, and I would love to correct the record and be able to submit that to the court. I called the clerk's office this morning, and they said, no, don't file a motion now because the argument is today, and so just to raise it with the panel. So I would like the opportunity to submit that so at least you can see that footer.
Go right ahead and submit that. And we have now reached the conclusion of arguments. Gentlemen, thank you so much. And this concludes the session of the Appellate Division, First Department for today's calendar. Have a lovely afternoon.
Thank you, Your Honors.
Thank you.
You too.